Good afternoon, and welcome to the Appellate Division First Department. Today I have a very long calendar, and so my usual spiel is going to be given with even more emphasis. Please ask for the time that you need, not the time that you want. We are familiar with the record, your briefs, and oftentimes more than you wish we were. The clock is for you, not for the court. So if my colleagues have additional questions because your arguments are so brilliant, I will allow them to continue. We have 8 hours of requested argument time. So I am not kidding when I ask you to please adjust your time request or the court will be forced to do it for you. Okay. People versus Tariq Jenkins. Five and 1 and 5. Wilson versus Bronx Lebanon Center. 4 and 2 and 5. C. Kalin is submitted. 435 Central Park versus Parkfront Apartments.
7 minutes for the appellant and 3 on rebuttal, please.
6 and 1 and 6. Independent 435 CPW versus Parkfront Apartments.
Respond in 5 minutes.
Give me your time request again? 5. Okay. 5 and 1 and 5. FX Funding versus Fox RX.
Your Honor, appellant requests 7 and 3.
Respondent cross appellant asks for 6 and 2.
Okay, 5 and 1 and 5 and 1. Greenage versus Steele. Okay. 5 and 2 and 5 and 2. Haruvi versus Hungerford.
Your Honor, appellant requests 5 and 2, please.
Okay.
Your Honor, respondent requests 5.
5 and 2 and 5. People versus Giapan. 2 minutes? Okay. 2 and 2. You guys take the prize today. Barros versus Bonos, 243.
The appellant, Bonos, 3 and 1.
Okay.
And 3 for the respondent.
3 and 1 and 3. Thank you. RC Children, submitted. Quinn Emanuel versus Avra Surgical.
Appellant requests 5 and 2, Your Honor.
Okay. 5 and 2 and 5. AAG Management versus New York State Urban Development.
Appellant requests 7 and 8. 8 minutes for respondent, New York State Urban Development Corporation.
Okay. All right, 6 and 1, 6 and 1. Batage versus Dahl.
Good afternoon, Your Honor. Appellant requests 4 and 1, please.
Okay. It looks like you're alone. Thank you. Rosenthal versus Sperling.
Appellant requests 7 and 2.
Okay. 7 and 2 and 7. People versus Pari.
Appellate request 4 and 2, please.
Okay.
Respondent requests 3.
4 and 2 and 3. Chan versus Havermeyer, both appeals are going to be heard at the same time, so give me your complete argument request.
For the appellant and cross appellee, and parties have converted, we each request 7 and 3.
Respondent cross appellant 7 and 3.
Okay, let's do 6 and 2, and like I said, if you're brilliant, I'm sure there's going to be more questions to take you to 7 and 3, okay? All right, first case on the calendar is People versus Jenkins.
Back up.
You may proceed. If you want to take a sip, go ahead. You may proceed.
Okay. Good afternoon, Your Honors, and may it please the Court. Kathy Liu, Center for Appellate Litigation, representing Appellant Tariq Jenkins. Hinton's warrantless search inside Mr. Jenkins' bag was unconstitutional. The emergency doctrine did not justify this search because at the time of the search, Hinton had already abated the risk that the gun inside the bag could somehow end up in the wrong hands.
So
This
what
is
is the
because-
suggestion? The suggestion would have been for law enforcement to just hold the bag and do nothing else?
No, Your Honor. So the appropriate course of action was to get a warrant. And the record
To get a
indicates-
warrant for a 911 call of a man brandishing a gun after having slapped a woman twice in a park?
Yes, Your Honor, because the emergency doctrine, which is the exception to the warrant requirement, did not apply since at the moment of the search, the claimed
Is
emergency
that what the
had
case law
abated.
says, that whether an emergency doctrine applies is confined to the exact moment that the police officers arrive on a scene?
And are we not to look to, I'm sorry.
Yeah, go ahead, please.
Look to the reasonableness of the officer's actions in terms of having felt that what was in the bag was a firearm?
No, Your Honor, that is not what the law states. The law states is that a warrantless search of a closed container is per se unreasonable unless it falls within the parameters of one of the recognized exceptions to the warrant requirement. And the exception at issue here is the emergency doctrine, which has 3 elements. And
The
as
bag
argued
that
in-
this was found in, did that bag, was that a purse?
so the record makes
Was it a purse?
it was a gold fanny pack,
A gold fanny pack?
correct?
And it was found in a stroller that had a child, an infant child in it, right?
Yes, Your Honor, but the only search that we're contesting on appeal is the search of the inside of the bag by unzipping it and looking inside. And
Counsel,
at the
how can
moment,
you argue that the emergency was abated by the officers taking possession of the bag when they don't know what's in the bag?
that is actually not what the record indicates, Your Honor.
They knew
The
there was a
record-
gun in the bag?
Yes, so
How?
because at the
At
time
best,
of
it's
the
probable cause that there's a gun in the bag.
Well, the record indicates that at the moment that he opened up the bag, he already had enough information to conclude that the gun was in the bag. He actually
He could have
Officer
been
Hinton
wrong. His
testified
information
that.
was what? That it was heavy.
No,
That it was heavy. There was a radio run of an armed dispute, right? And then you had another person saying that there's a gun in the bag.
well, there are actually multiple sources of information for him to form the conclusion that the gun was actually, in fact, in the bag.
What was the
This is
officer to do
based
with
on-
the bag afterwards?
So again, the officer could have gone to get a warrant, and
So
the
he was
record
supposed to
indicates-
stay at the park, one officer was supposed to stay at the park,
Well, the record actually.
while another officer went and got a warrant. That's what you're saying.
So there were multiple opportunities for him to get a warrant. One of the possibilities is as soon as he confirmed that the gun was in the bag, based on the bystander's tip and feel of the outside of the bag, during which he felt a hard metal object in the shape and feel of a firearm, he could have, instead of opening up the bag, he could have left the premise to get a warrant. Alternatively, after Mr. Jenkins had been apprehended, since that there were 5 officers at the scene, one of them could have left to go to the precinct, while the remaining 4 stayed at the scene and remained control.
And
Under
what are you
both
suggesting they should have
circumstances.
done with the bag that they believed contained a gun while they were going off to get a warrant?
Stand on the street, apparently.
Well, actually, that is what Officer Hinton did. So after he opened up the bag and found the gun inside, he testified that he didn't do anything to make the gun safe. He didn't.
It was
remove
in
the
his
ammunition.
possession,
Right, but if he took it, out
which
of the
means
park-
that it's safe because I can't imagine an officer is going to allow anyone to come up and take the gun from him.
Right, but that is precisely why there was no ongoing emergency at the time of the search, because there was no belief that anyone would have taken the gun from his hands. That is exactly why there was no ongoing emergency. He had baited the emergency once he took the bag from the stroller, felt the outside, and confirmed that the gun was inside.
Didn't he abate the
Plus-
emergency when he looked in the bag and saw, I got the gun that I'm looking for?
No, because the emergency had already abated before that when
It
he
just
was
happened to be the case. But how about a circumstance where there's a heavy object here, and it turns out that it's not the gun, and the gun is somewhere else? Ongoing
under
emergency,
those
right?
circumstances, which are not the facts of this case.
But we
yes,
have
there
to
would still-
analyze the law on giving the probability and the reasonableness of the officer's conduct.
No,
So
Your
here,
Honor.
the abatement comes once the officer's ensured that he has the gun.
Again, the officer was able to confirm the gun was in the bag based on the information that was already
Okay,
available.
you'll have time on rebuttal because you've made that argument several times now. You may proceed.
May it please the court, Alex King for the people. The emergency doctrine.
So your adversary says the officer had the gun. Emergency over. What do you say?
Now, that's not correct, Your Honor. As a matter of common sense, it's extraordinarily dangerous for a gun to be left unlocated and unsecured in a public park that is full of children on a summer afternoon. Defendant suggests that Officer Hinton should have stood idly by after touching the bag, but as Your Honor's questions suggest, not only would that have been unreasonable, it would have been downright irresponsible. In fact, a dereliction of duty for Officer Hinton not to confirm that he had in fact found the gun and thereby abated the emergency.
Counsel, what about your adversary's argument that upon finding the gun, he did nothing else with it, such as to make it safe?
What he did is he safeguarded the gun. He stood there with it, and what he had to do to abate the emergency is to make absolutely certain that he had found the gun. It was not that he thought that he had the gun. He had to make sure that the gun was there and thereby abate the emergency. This same fact pattern of a gun that is left unlocated and unsecured, dangerously close to children, recurs with unfortunate regularity in this state and elsewhere, and courts have repeatedly held that the emergency doctrine justifies a warrantless search to find the gun and thereby abate the emergency. If there are no questions, we ask that you affirm.
Thank you. You have 1 minute.
Yeah, so my adversary says that the park was full of children at the time of the search. That is not supported by the
Well, but
record.
wait a minute. There's a sense that the gun is around in the vicinity of the stroller. There's a baby in the stroller. Wouldn't it be for the protection of the baby, the mother, and the police officers that the officers would have to locate that gun to secure it?
Right, but at the time of the search, Hinton had already seized the bag containing the gun and then already confirmed that the gun was inside.
You
based on
keep
the
saying
bystander-
that. You keep saying that by picking it up and feeling a hard object, he confirmed a gun.
Yes, and that is
And if this court finds that it was only confirmed when he opened the bag and visualized the gun as he testified, then your argument falls flat.
I understand, Your Honor, based on what you're saying, but that is not what the record states. On page 54 of the suppression record, Hinton testified that based on his experience and training as an officer, he was able to conclude before even opening up the bag that the gun was inside based on the bystander who had been at the scene the entire time that he was there, yelling out to him, the gun is in the stroller, in the bag on top of the stroller. And then after he picked it up, he testified, quote, I found a hard metal object in the feel and shape of a gun. So based on his training as an officer, he had already concluded that the gun was inside. And
Thank
because he
you.
had done so, a visual inspection was no longer necessary. Thank you.
Thank you. Wilson versus Bronx, Lebanon.
Good afternoon, Your Honors. I'm Judy Shamitzi with Wilson Elser for Bronx, Lebanon. Your Honor, the defendant's expert here has established that it is physiologically impossible, but for the plaintiff's head flipping back quickly for this particular injury that caused his paralysis to have occurred in the manner that he described.
Well, assuming you make out a prima facie, what should we make of the plaintiff's expert saying that the injury occurred when there was a rotation of the neck and when the plaintiff fell to the ground? Doesn't that create an issue of fact?
Your Honor, the portion of the plaintiff's expert that the plaintiff's expert's opinion that rests on the record as it existed prior to the IME. The deposition testimony, the medical records, actually is in agreement entirely with the defense expert. The only new bit of information that the plaintiff's expert has, and this is key to the plaintiff's expert's opinion, is that the plaintiff's head snapped back after he was, so he's hit from the back on the head, and that his head goes back from the direction that he was hit in. That is the new bit of information that the plaintiff's expert has, only because the plaintiff told him that during the IME. But that critical fact is inconsistent with every description he gave during his deposition
He
testimony.
was never directly asked whether his neck rotated or head snapped back. Is that right?
Your Honor,
And as a result of this, he was rendered unconscious, correct?
not entirely, Your Honor. He was asked
A
questions.
little unconscious?
A little, I mean, come on.
He
You're
was-
either unconscious or you're not.
Oh, absolutely. And he was asked, when you were hit in the back, did you pass out? And he said yes. And he described the events multiple takes. All right, he described them multiple times. And every time he describes this, the sound seems to have registered with everybody, although everybody interprets it differently, that he heard the sound of being hit and then he immediately passed out. That is consistently his testimony. So he was asked questions, Your Honor, I don't mean to be evasive about the question, he was asked questions that called for that answer. If that were true, in being asked to describe what happened, in being asked, did you pass out when you were hit in the back? And he says, yes, I did, immediately and repeatedly he says that.
Isn't there also a problem with your expert's theory that there was no marks at all on Mr. Wilson's face?
Well, the testimony, Your Honor, from the person who saw him go head first into the window is not that he went face first, but that he went with the crown of his head first.
Well, is there anything in the record to suggest that he had injuries to the crown of his head?
Well, so the injury that there is not a bruise per se. The injury that happens when you do that is this kind of herniation.
So you're saying that someone that's leaping towards a closed window and hits the window or part of the window with the crown of his head is not going to have any other injury to the head itself?
They may
Such
not,
as
Your Honor.
swelling or
How is that any different from the lack of injury to his back from being hit from the back?
Right, he hits this window supposedly so hard with the top of his head that he knocks himself out and renders himself a quadriplegic.
Yes, Your Honor.
And there's no other signs or indicia of trauma to his head.
Yes, Your Honor, because of the,
And that makes sense.
Your Honor,
And that should not be before a jury.
that is the expert's opinion, which is
And
not
we have
rebutted
a
here.
countering expert. So why is this not
Because
the quintessential battle of the experts?
Because the countering expert relies on a fact that is not supported by the record and is in fact contrary to the plaintiff's deposition testimony, Your Honor.
And what is that?
That the plaintiff's head snapped backwards, that is the only way that the plaintiff's expert is able to explain how this injury would have
What I
occurred.
have in a record here is that this man is hit, rendered unconscious, and then he is flipped over. There's no commentary about the security officers who hit him getting medical personnel to make sure, put him on a backboard to make sure that his neck is secure. No evidence that a collar was put on him before they flipped him over. So as far as I'm concerned, it seems to me that these two experts can battle it out about how he ends up a quadriplegic.
May I
Because it's not so sure, it's not so clear to me, based on both of these experts, that there's one cause, and we know from our case law that there can be two competing causes. I'm still talking. Two competing causes for causation. Now you may answer.
The radiology films show there are unfortunately many ways that a spinal column can be severed in that way. The radiology films here show the precise mechanism of injury, and that requires that the plaintiff's head snap backwards, which the record here does not support.
Okay.
Thank you, Your Honor.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. The plaintiff was never asked what happened to his neck.
So there's no evidence, you would concede, that in the record that his neck rotated when he fell.
Not evidence by him, no, but the plaintiff's experts.
What's the evidence that we could, or infer from it, in fact, that it's evidence, that the expert's opinion is based on evidence?
Well, it doesn't necessarily, plaintiff's expert didn't say it had to necessarily snap back. It was just his neck had to rotate in order for the facets to fracture, in order for the paralysis to occur. So here, whether he was hit in the back of the neck, in the stairwell, what he says, or he was tried to hit the window, then fell back, there's still the element of the security officers restraining him, kicking him, doing something to him that may have led to a rotation of the neck. And that's what the defendant's expert doesn't address. He never addresses. His problem is paragraph 8 of his affidavit. He says that this can typically happen to a blow to the front of the head, but he never addresses what an atypical situation was. He never explains how this injury could have occurred being hit from the back. That's plaintiff's essential allegation, which they have to address and disprove. So our expert, even he explains that his opinion is that had to have rotated. How it rotated, was it rotated from him being struck from the back, then twisting and falling in the stairwell, or even the ACN clinic? Could it have been there? Could it have been as a result of the security officers restraining him, which the medical records bear out? They say physical restraint by security officers, police tackle, now plegic. So we have these questions as to how exactly did his neck rotate. On a summary judgment motion, they didn't even, the defendant's expert didn't even address that, did not address that, which my expert does at 7408 of the record. So that is a question for the jury as to how this occurred, how the cervical facets were fractured, because that is what caused this. It's the rotation of the neck. Both experts agree that this was a hyperextension injury. The issue is, how did his neck rotate? Did it rotate?
So, counsel, if there's no injuries to his back or the back of the neck to suggest any trauma, that's irrelevant to your argument because the expert opinion is based on something else could have caused a hyperextension?
That's correct. He said that it was a rotation of the neck that caused the facets to fracture. In addition to that, our position is that the defendant's experts don't reconcile, as we discussed when my adversary was up, he doesn't reconcile how he could have jumped headfirst into a window and had no intracranial pathology because the top of the head is the cranium. So that is another aspect of the defendant's affidavit which doesn't support summary judgment, whereas my expert says—
Well, could bruising have been covered by hair on the scalp?
It could have been, but it's nowhere in their affidavit.
Did he have any bruising to his face? Because I'm assuming if he jumped into a window head first, he would have fallen on his face based on the photograph that's in the record.
Correct. There is no evidence. And what's also interesting about the photograph is that there's a line of chairs right by window ledge. So it's strange how he may have hit the window, if that's what he did, and fallen back and had no bruising to any part of the front of his face. One last thing before I sit, I think it's very relevant that there's surveillance camera in this ACN clinic. It's all over the ceiling at 7412 of the record. If plaintiff is not telling the truth, that video evidence ends it, and the defendant fails to produce it. Again, that may be subject to an adverse inference at trial, but I think it's very relevant on this record, the fact that that surveillance video was not proffered. If you have no other questions, I'll rest on my brief. Thank you.
Thank you.
Your Honor, this is the
Counsel,
first
would
time.
you address the striking absence of the surveillance video?
Yeah, I really can't. This is the first time hearing of it. It was not
Really?
part of our.
It was in the record that,
Well, it wasn't part of our briefing, and I don't know if
it was
there
in the
is-
record, I believe.
Yes.
What I'm saying is it had never been part of the issues on why this and how this injury could have occurred. I don't know.
I don't understand that argument.
I don't know, Your Honor. I do not know as I stand here today if there is a video of that area and where that video may be. We had not discussed this in the briefing, and I simply don't know.
Bronx, Lebanon has video all over
Your Honor,
the emergency
Your Honor,
room.
I am happy to.
Counsel, I'm
ask
still
that it-
talking,
I do
okay? I understand you'd like to kind of get past the lack of a video, but it seems to me that, as your adversary said, that could put this all to rest. If there was video to confirm, as your client suggests, that he attempted to throw himself out of a window.
Your Honor, I am happy to inquire of my litigators what the status of the video is and advise this court accordingly, but in the briefing, we had not covered that issue, and as such, I don't have
Okay,
information
counsel,
about
what
the current
about
status
what
of it.
your adversary has put forward in terms of a potential cause of the injury, which is perhaps the security officer stepping on her client? Was that always the initial theory of their case, or of how the injury happened?
The precise mechanism of the injury didn't come to be fleshed out until the summary judgment affidavit was submitted. So that is the point where the plaintiff would have been confronted with the physiological reality of the type of injury, exactly the type of injury that he suffered, and our expert's explanation. The only
Did your expert put in anything to refute the claims of this rotation potentially coming from the security officer stepping on the plaintiff?
The defendant's expert opinion is that the way that this happens is you need to have the head snap backward in the way that the plaintiff ultimately described. After they get our expert affidavit, the plaintiff goes and tells a story consistent with our expert's physical narrative of what needs to happen for this injury to occur. The plaintiff goes to his own IME, tells a story to his own lawyer's physician, and says, oh yeah, that's exactly what happened, that's how I got injured. That's the problem with the timing of this IME and that statement, is the experts are in agreement about what physically needs to happen to the head for this type of injury to occur.
All right, thank you.
Thank you, Your Honor.
435 Central Park versus Park Front Apartments.
Good afternoon. May it please the
Good
court.
afternoon. You may sit.
Jeffrey Turkel for the appellant. Chapter 95 of Laws of 2024 states that the legislature's intent was to define clearly the scope of the fraud exception to the pre-HSTPA 4-year rule. The legislature did so by repeatedly stating in the critical paragraph that the sole exception based on fraud to the 4-year rule was a fraudulent scheme to deregulate a unit. I don't think it can be more clear than that. In 2020, the owner came before this court and argued that the tenant's fraud claim should be dismissed because the tenants had not alleged a fraudulent scheme to deregulate. This court said, you don't have to allege a fraudulent scheme to deregulate. You can allege a fraudulent rent overcharge scheme. The court could have said that what the tenants alleged qualified somehow as a fraudulent scheme to deregulate. The court could have said that fraudulent scheme to deregulate encompasses a fraudulent rent overcharge scheme, but it didn't. It said that there is a second basis, and the tenants qualify only under the second basis, and that's good enough. The court didn't have Chapter 95, which was enacted in, I think, in January of this year when it made its ruling in 2020, but it has it now. And as I said, the Chapter 95 is very, very specific. As I said, 3 times fraudulent scheme to deregulate. And I think what's even more critical is that Chapter 95 came a couple of weeks after Chapter...
Our decision did not say it wasn't also a scheme to deregulate. It only said that it was a scheme with regard to overcharges, but we didn't say it was not a scheme to deregulate, correct?
Well, yes, Your Honor.
Do you agree?
Yes, Your Honor, but if the court found that it was somehow a fraudulent scheme to deregulate, it never would have had occasion to talk about a fraudulent rent overcharge scheme. What would be the point if it fell under a fraudulent scheme to deregulate to say that, well, there's also a fraudulent rent overcharge scheme?
That may have been the more salient point at that moment, but that doesn't mean it precluded the other, right?
Okay, Your Honor, I'll take that. But now we have Chapter 95. And Chapter 95 comes 4 years after this court's ruling in 2020. So even if it's not law of the case, the court still has to decide this under Chapter 95. Chapter 95, as I said,
So that's something that we would now have to decide, not having to...
Yes, absolutely, absolutely. Chapter 95 repealed much of Chapter 760. And Chapter 760 said, it defined fraud in an extraordinarily broad way. It said that it's basically any conduct by a landlord undertaken for purposes of claiming an unlawful rent or claiming to have deregulated an apartment. That's stated in the disjunctive. So there's two. One is claiming an unlawful rent. That would be codifying a fraudulent rent overcharge scheme. And the second one, as we know, is claiming to have deregulated an apartment. A couple of weeks after Chapter 95 was enacted, after Chapter 760 was enacted, Chapter 95 comes in and it wipes out all of that language.
And that issue was never addressed by the motion court, obviously.
We advise Supreme Court in correspondence, which is mentioned in the briefs, that there is a statute that's just about to come out.
Okay, but it was never addressed by the motion court, correct?
No.
You may have advised them in correspondence, which apparently is not part of the record, which we'd prefer you not talk about, but, so that was never addressed?
No, it was never addressed, but
Okay.
it's well settled that an appeal is to be determined based on the law in effect at the time of the appeal, not the law in effect at the time of the original decision. So Chapter 95 comes up. Chapter 760 codified a fraudulent rent overcharge scheme. Chapter 95 repealed that. There was no fraudulent scheme to deregulate in this case. As a result, we respectfully submit that renewal should be granted, and upon granting renewal, we should be given summary judgment dismissing the tenant's claims of fraud with respect to the 5 subject tenants. Thank you.
Thank you.
May I commence?
Yes, you may
Okay.
proceed.
So the parties agree that Chapter 95 restored the pre-HSTPA law, the pre-Regina Metro case law, mainly Grimm and Thornton. That's not in disagreement right now. When this court decided the questions that were in front of it in May 2020, Grimm and Thornton were the controlling law. So effectively, there's been no change in law. There's no reason for this court to overturn that decision. The stated purposes of Chapter 95 are to restore Grimm and Thornton, and so the court has to look at what Grimm and Thornton say and what Grimm and Thornton and that line of case law consider to be fraudulent schemes to deregulate. That case law includes various schemes to deregulate. What the appellant is now asking the court to do is to limit the scope of that case law.
What precisely is your claim here? Are you making a claim that there was a fraudulent scheme to deregulate, or not?
So this is indeed a fraudulent scheme to deregulate.
But are you making that claim here?
Yes.
How are you making that claim?
So under Thornton and Grimm, there was no distinction between a fraudulent scheme to deregulate and fraudulent overcharge schemes. Thornton involved a temporary exemption from rent stabilization at a time when luxury deregulation was not possible. There was no permanent deregulation. There were no deregulation riders that apprised the tenant of what had occurred. And the Court of Appeals highlighted the temporary nature of this exemption later on in its Coniston decision. So simply put, Thornton involved what the appellant is trying to call a fraudulent scheme to overcharge. The court called that a fraudulent scheme to deregulate. Similarly, in Grimm, first of all, the tenant was paying below the threshold for luxury deregulation. The landlord had offered the tenant a higher rent and a lower rent contingent on doing repairs. This arrangement is exactly what we see in a rent-stabilized apartment where there's a legal rent and there's a preferential rent. There was also no deregulation rider. After the tenant complained and did a rent overcharge complaint to DHCR, the landlord then provided the tenant with a rent-stabilized lease. The apartment was not actually deregulated. So this case also involves a scheme to overcharge that the court called a fraudulent scheme to deregulate. Similarly, in Coniston, which is addressed in the briefs, the landlord didn't claim that the unit was exempt. The landlord just stopped registering rents with DHCR. The landlord gave the tenant a lease that included, that said that there was a legal rent, had a lower rent, and there was no deregulation rider. This was a scheme to deregulate, to overcharge. The unit was not deregulated. And in all of these three cases, the Court of Appeals called these schemes fraudulent schemes to deregulate. It's clear that the Court of Appeals intended the term fraudulent scheme to deregulate to include the schemes such as the schemes that are present in this case. The language in Chapter 95 matches the language that is in the case law that it seeks to restore the authority of. The facts here are very similar to Grimm, Coniston, and Thornton in that the landlord here didn't alert our clients to the fact that their tenancies were subject to rent stabilization. Our clients were told that their tenancies were subject to HUD regulation. There was no reason for our clients to commence litigation within the 4-year look-back period. The landlord then, by the way, did not comply with the HUD procedures. The courts in Thornton, Grimm, and Coniston paid very close attention to landlords' fraudulent actions that tampered with the rent on the base date, that rendered it unreliable. And that's precisely what happened here. And this department, in its May 2020 decision, found that plaintiffs' pleadings were sufficient and that there was enough evidence to raise an issue of fact for Supreme Court to rule on as to whether the landlord had misled the plaintiffs and overcharged them. So the state, as I've discussed, the stated intent of the recent amendments is to restore the authority. It also states an intent to discourage and penalize fraud against the rent regulatory system and to tenants. Right now, the appellant defendant is asking this court to interpret this amendment as an amendment that permits and forgives fraud, so long as the fraudulent scheme was only to charge tenants unlawful rents. By the way, unlawful rents, which can and very likely do lead to deregulation in the future. This interpretation reduces the scope of landlord liability for its fraudulent actions, which goes against the stated legislative purposes of this amendment, and has the opposite effect of discouraging and penalizing fraud against the rent regulatory system. Now, I do just want to briefly mention the legislative...
You are almost out of time.
Okay. Okay, so, in summary...
You are out of time, so I'm going to give you 20 seconds to finish your thought.
Okay, so in summary, nothing has changed in the state of the law. The facts here are similar to Grimm, Thornton, and the legislative intent, as stated in the statute, is in our favor.
Thank you. You have 1 minute.
I do. Thank you, Your Honor. The legislature wanted to restore Thornton and Grimm because Thornton and Grimm did not require the tenant to prove the common law elements of fraud. That's a big part of Chapter 95 and Chapter 760.
The legislature never says that that's the only purpose of the amendment, right?
I'm sorry, I didn't hear.
The legislature never said that was the only reason for the change.
No. The other part was to clarify what the fraud had to be, and they 3 times said fraudulent scheme to deregulate, and they repealed the language about a fraudulent rent overcharge scheme in Chapter 760.
Was there a claim here by the tenants that there was a fraudulent scheme to deregulate?
Never. Never. Not in their complaint. They didn't do it until we moved for summary judgment.
Would a fraudulent scheme to overcharge, would it be a subset of a claim? Would it be a subset of, or a probable result?
Well,
deregulation, as counsel argued.
I don't see how Chapter 95 would support such an interpretation. Chapter 760 said fraudulent overcharge scheme or fraudulent deregulation scheme. Chapter 95 wiped out the fraudulent overcharge scheme. There's nothing in the statute that supports the claim that something other than a fraudulent scheme to deregulate will satisfy the statute to breach the 4-year rule. Thank you.
Thank you. Independent 435 CPW versus Parkfront Apartments. You had such a long way to go. All right, you may proceed.
Good morning. May it please the court, W. Miller Hall for appellants. This case concerns the same building. Unlike the case that they were discussing, the tenants in this action aren't seeking to go beyond the 4-year rule. They're not they haven't asserted a claim that of fraud. It's really more, it should have been a straight overcharge claim. Now, the real question that the court has to answer is given that this court has determined that the building was subject to stabilization in April 12th, 2011, what are the consequences of that? And the central issue here is that the court has to determine whether a building that has never been treated as stabilized, no apartments have ever been treated as stabilized, can they then be deregulated? At least
I
as
have a
to
question for you. So one of your defenses is that the landlord failed to assert in its answer the defense that the tenants were deregulated by reason of luxury decontrol.
right.
How are your clients, are you claiming that your clients were prejudiced by that? And if so, how?
Absolutely. In the first instance, the pleading itself, which I believe is in the record at 187, is identical to the pleadings here. So there was no assertion of anything other than preemption under federal law. There was a vague mention to documents, but then referencing.
Right. I know what it says. I'm curious whether your clients were prejudiced by what it said, by their failure to assert the claim they're now making, which is that your clients were deregulated because of luxury decontrol.
Yes, because we would have sought discovery on those issues. Most of the.
You would have started what?
We would have sought discovery on the issues.
Okay.
Most of the deregulated apartments, of the 11 that were deregulated, were largely because the court allowed brand new IAI defenses in order to deregulate the apartments, allegedly. But we had no prior notice. Respondent claims in his papers that, well, we shouldn't have been surprised because the registrations should have reflected that. Those registrations weren't filed until April of 2022, which is after the note of issue was issued in this case. So discovery was already over. So the first time we know anything about the details is in their cross motion. Now, it is true that a cross motion on an unpleaded defense could be a basis to deny summary judgment, but it can't be the basis for summary judgment. And the other thing is that this idea of that we should have known. Well, the contrary, if the landlord was not required to plead a specific exemption, the contrary is there's over 20 exemptions.
Counsel, I have a related question, which is that I believe one of your other defenses is that your clients weren't given any of the procedural protections which would normally be accorded to tenants as to whom there was luxury decontrol. Were your clients prejudiced by that, by the failure of the landlord to give procedural protections that are required by the rent stabilization law?
Right, because I mean, not only were the tenants prejudiced, because the apartments could not be deregulated without all of these procedural requirements. They needed to have rent stabilized leases, they needed to do an exit registration, they needed to do notice, they needed to provide 1 or 2 year options, all of those things. And it's not just the tenants, because when it comes to, this is a regulatory scheme that requires certain procedures. If those procedures are not followed, and this is precisely what matter of AEJ 534 is relevant to. You can't, there was never just automatic deregulation. You had to do all of these things. If the landlord had in fact done them, the tenants could have challenged those rents, they could have investigated the claims, they could have done all of these things well before. And in fact, they could have had an overcharge claim earlier. But the integrity of the system itself is what matters. But underlying most of the lower court's decision is this concept of,
You can finish your thought.
Is the concept of this good faith exception. And I'm sure that it does not relate, this is not a J51 building. The only good faith exception is as found in post-Roberts J51 cases.
All right, you can tell us about that on your time on rebuttal.
Thank you, Your Honor. Jeffrey Turkel again. Let's talk about the Park case, because in the Park case, there was no deregulation notice. There was no registration. There was no stabilized lease. There was no stabilized rider. And yet,
In that case, did the landlord claim that the apartments were not and had never been subject to regulation, as you did in your answer?
in that case, the landlord, well, if I can take 30 seconds and set forth what the facts were in there. 2004, I'm sorry, would you
Like an answer to my question.
if you could just restate it, Your Honor, I'm having trouble hearing.
In that case, did the landlord seek a declaratory judgment that the apartments were not and had never been subject to rent stabilization, as you did in your answer?
I'm not sure, Your Honor.
Okay, but how is it that you can claim in your answer that the apartments never were subject to rent deregulation and now be claiming that the tenants are ineligible for rent stabilization because of luxury decontrol? How can you have it both ways?
Well, I don't think we're trying to have it both ways, Your Honor. I'm looking at the Park case.
So you're having, but I'm asking you, how can you ask for declaratory judgment that you were never subject to rent stabilization and claim that they are exempt from rent stabilization because of luxury decontrol, which would only apply if they were subject to rent stabilization?
No, these particular tenants, these 11 tenants, were never subject to rent stabilization. Their predecessors were, but they were not.
So,
But that still doesn't answer the question, counsel.
Alternative theories are permitted, Your Honor.
Okay. That answers the question.
Thank you.
maybe.
In Park, thank you. In Park, the building was receiving a J51. In 2004, the rent-controlled tenant vacated. The owner, as was permitted under the statute, took a 50% increase over the rent-control rent, put $200,000 into the apartment, raised the rent to $7,000, and treated the incoming tenant, Mr. Playfair, as deregulated, but that was wrong, because DECR had advised this landlord, as it had advised all other landlords, that you could get luxury deregulation while you're receiving J51. The J51 expires in June of 2010, after Roberts, I might add. 3 months later, Mr. Playfair, the first tenant, moves out, and then Ms. Park moves in. Ms. Park was not served with a deregulation notice. The apartment was never registered as stabilized. The apartment was never treated as stabilized. She wasn't giving a stabilized lease. She wasn't giving a stabilized rider. Nevertheless, this court said all of the conditions for luxury deregulation have been met. And the primary condition for luxury deregulation, that the rent is over $7,000 a month, that was based on MBR increases plus individual apartment increases that the court granted, if I may finish, that the court granted the owner even though there had been no registration.
Counsel, in Fuentes versus Quick, we held that an apartment could not be deregulated under luxury decontrol where it hadn't been properly registered. How do you get around that?
I get around it because those cases were not post-Roberts type cases. In those cases, DHCR never told the landlord, you can ignore all these rent stabilization provisions. The landlords therein just said, we're going to ignore them on our own. In this case, DHCR said to the owner, as long as HUD is regulating these buildings, you don't have to worry about rent stabilization. You don't have to abide by rent stabilization. So what the tenants are saying is, because the owner wrote to DHCR under the peculiar facts of this case and said, we want to know whether or not the existing federal preemption is going to continue. And DHCR in 1999 said it would. And based on that, and reliance on that,
They asked for an informal letter as opposed to actually undergoing a proceeding to have that determination made, right?
and the same is true in Park, and the same is true in Regina, and the same is true. In all the post-Roberts cases, they were relying on a prior opinion letter that DHCR sent to one owner's attorney. Here, the owner wrote to DHCR and said, I need to know what the answer is. DHCR gave him the answer. DHCR said, you don't have to abide by rent stabilization for the next 15 years, and the tenants come before this court and said, you should punish the landlord for listening to DHCR. You should take away luxury deregulation, you should take away all the rent increases, and you should freeze the rents. That's not fair. Park said that's not fair. Park said that abusing the landlord, punishing the landlord in that fashion, does not further any intent or motivations of the rent stabilization law. It's just purely punitive.
Counsel, one more question. Given the purposes of the HUD program under which this building was initially funded, received funding, isn't permitting luxury decontrol under these circumstances inconsistent with the purposes of that program?
This court ruled in 2018 that as of 2011, HUD was over. And we're saying that all of the deregulations took place after 2011. I mean, we can't be subject to HUD and not subject to HUD at the same time. This court said, you're stabilized. Okay, we're stabilized. This court has repeatedly held in 5 different cases that once the J51 ends, an apartment can be luxury deregulated if the attendant circumstances for luxury deregulation are present as they were here. Thank you.
Thank you. FX Funding versus Fox RX. You may proceed.
Good afternoon, Your Honor. Sheldon Gopstein, representing the appellant, FX Funding. Your Honors, the sole ground cited by the court below for denying plaintiff's motion was that it was an improper successive motion for summary judgment. If not for that misapplication of the doctrine, the court below actually did a great job of showing or demonstrating.
Is that a misapplication of the doctrine?
Oh, because, for the reasons that this court stated in this very case on this same issue. This is now the second time we're appealing the exact same issue. And this court said that it is improper. The doctrine, the doctrine generally prohibits attempts by a party to revisit prior unsuccessful motions. There was no prior unsuccessful motion. The prior motions were successful. They were granted. They were motions simply for summary judgment under the promissory notes, just to get judgment under the notes. This is an entirely different motion that could not possibly have been brought prior to the close of discovery. We did years of discovery in this case. In order to pierce the corporate veil, we got third-party subpoenas, we took depositions, interrogatories, notices to admit, all sorts of things could not possibly have been brought prior to, and wouldn't have been proper to bring before the close of discovery. And this court, on the same issue, in this same case, said that, courts should be, and I'm quoting this court, courts should be loath to sustain a meritless action or defense upon purely procedural grounds. So this is a misapplication of the doctrine. It's not an improper successive motion for summary judgment. And unless you have further questions on that, I'm going to move on to why now the motion should have been granted for all the reasons that the court actually mentioned. She dissected, did a great job of dissecting the defendant's arguments. In order to pierce the corporate veil, we have to prove that there was a complete domination and control.
So starting with Rena, how have you shown that there was complete domination by Rena?
She was everything. She was the president, CEO.
There's nothing wrong with that, right? I mean, she owned the company. She apparently signed off on checks through stamps. But how was there a domination?
Absolute absence of any corporate formalities. This was a piggy bank for Rena and Deepak. There were no corporate resolutions. There were no shareholder meetings. There were no board of directors meetings. They never appointed a board of directors, never elected a board of directors. There was not even bylaws. They didn't even adopt bylaws. They admitted over and over again that there was a complete absence of corporate formalities. This is one of the primary principles of how a person dominates a corporation. She's the 100% shareholder, completely dispenses with all corporate formalities, and they take all the loan proceeds and they use them for their personal.
But doesn't the record tend to support the suggestion that it was her husband who drove the bus?
Yeah, he tried. He did a great job. He tried to valiantly say that, except she was the only signatory in the bank account.
Yes, but they had a rubber stamp for it, literally. They literally had a rubber stamp with her signature, and put it wherever they wanted. How does that show that she exercised complete dominance?
She was the only one that she signed the promissory notes, the security agreements. She signed the escrow agreements, the
Well,
retainer
she's doing
agreements.
all of the things that you would do as a corporation in the name of a corporation. How does that take it out of that realm and make it that she's completely dominating the corporation in the same way that her husband claims that he did, admitted that he did?
Because under the case law, first of all, she did all of the loans were taken, all of the documents were signed by her, the IRS forms,
We have case law
everything.
that says signing of documents alone under the name of the corporation is not sufficient to sustain complete domination.
Combine that with a total absence of corporate formalities.
Well, is
That's
that
where
really-
it is. That's where you get it.
Is that your argument? In essence, it's a failure to follow corporate formalities by RENA, and coupled with, I was looking over how
Yeah.
the expenses were going out. It appears, unless Deepak is getting his nails done,
It was a whole, they took the entire loan proceeds and used them for their family. Not $1 was used for a legitimate corporate purpose.
All right, you'll have time on rebuttal.
You got it. Thank you.
Good afternoon. May it please the court, Michael Hiller, BC, on behalf of the defendants, respondents, cross appellants. I'm going to turn to the questions that were just being addressed, and that pertains to Reena Nandi. As this court is well aware, it is reversible error to undertake an analysis with respect to piercing the corporate veil that does not individually assess the conduct of each individual defendant. In fact, in Cortland State Recovery versus Bonderman, 226 AD 3rd, 103, this court actually reversed on that very basis. And yet, if you look at the record below, at pages 10 and 11 of the record, you will see that that's exactly what the trial court judge did here. She lumped the two individuals together and created an effectively...
Let's deal with Reena.
Sure.
So there's not domination in the classic sense, but your adversary says corporate formalities weren't followed, and then there was a fraud or injustice by using those corporate expenses for personal expenses.
Right, so the two requirements for piercing the corporate veil are total, complete domination of the corporate entity, and secondly, use of that corporate domination in order to cause a specific harm to the plaintiff. That second piece actually is broken down to two different component parts. Number one, there has to be damage to the plaintiff, and number two, it has to have been caused by the conduct of Reena Nandi. Plaintiff's counsel did not explain how it was that Reena did anything to cause any damage to the plaintiff. The plaintiff's damage, if he's claiming it.
So are you conceding that he's established that she played a role in complete domination of the corporate form?
No, quite the contrary. I was just dealing with the second part first because I think it's a lot more clear. But if we take a look at this, at the first piece, which is total and complete domination, if you take a look at the record, you'll see that at pages 146 and 147 of the record, Reena Nandi indicated during her deposition that she signed the documents that her husband had placed in front of her. She did not even recognize the promissory notes or security agreements when they were shown to her until she looked at her signature. Her husband, at pages 173 and 179, acknowledged he had fully negotiated the promissory notes. He also made the determinations as to how the money was spent. By contrast, Reena Nandi was not involved in any of the financial transactions pertaining to loan proceeds.
Let me stop you there. One of the records is her taxes are paid.
I'm sorry?
Her taxes are paid. And there's a stamp, it appears to be a stamp, but her name is on the ledger line, and it's for payment of taxes. She wouldn't have been aware that her taxes were being paid with these monies?
I would respectfully submit, Justice, saying that what you're talking about is whether she should have been aware, and that's just not the standard.
The question was whether she was aware.
She was not aware, Judge.
That she should have been aware as the president of the company sounds like a resounding yes.
As president of the company, she would not be the first president of the company not to be found liable because someone else was engaging in the transactions that were determining whether or not the loan proceeds were used for other non-borrower expenses.
So the fact that these loan proceeds are used in part to benefit her, as in the payment of her mortgage, we should ignore the fact that, according to her, she knew nothing about it. But but she reaped a personal benefit from the use of that money.
And Judge Manzanette, what I would say to you respectfully is that even if that were true, that would not be enough to impose personal liability against her. I respectfully referred to you Do-Gooders Products versus American Jewish Theater, 226 AD 2nd.
But the claim here, counsel,
103.
the claim is not so much domination. What I'm hearing from your adversary is a failure to follow corporate formalities, bylaws, boards of directors, all those kinds of things, which presumably would be in place to check that kind of behavior.
But if I can leave you, I only have 1 minute left. If I can leave you with one thought in response to that, it may be the most important thing I'm going to say to you today. In order for the plaintiff to prevail on this theory, they must show that the absence of corporate formalities or the payment of a mortgage, assuming that's the case, caused the plaintiff damage. The plaintiff's damage here, according to the plaintiff, is that they weren't paid the money back. But if you look at the record at 3679 to 81 and 3682, what you'll see is that the Giapan lawsuits were supposed to be the monies that would comprise the repayment of plaintiff. There is no allegation, much less proof, that absence of corporate formalities.
So in other words, your clients can allegedly commit a fraud, strip the company completely of money. The plaintiff gets a judgment against a shell, and you can say, there's no personal liability here because the monies, the Giapan lawsuits were frivolous, and no monies would come from it.
I'm out of time, but I would love the opportunity to respond to that.
Yes, of course.
Thank you so much. No, my client, number one, there's no evidence that she was involved in any of the specific transactions to which you refer. But the larger point is, in order for the plaintiff to prevail here, there must be evidence that shows that Reena Nandi and Deepak Nandi prevented the payment of the loans back. That's what the law is. If you look at Ricardo versus M3 Innovations, Berlin Associates versus Kicken, both of which we cite in our case, in our briefs, you will see there has to be some showing that Reena Nandi prevented the repayment or in some way interfered with the Giapan lawsuits. Those Giapan lawsuits were contingency fee cases. All expenses were advanced by the lawyers, which means none of these loan proceeds could possibly have been prevented to be used to prosecute those cases. Those cases were being prosecuted. The fact that the cases did not work out doesn't mean that Reena and Deepak Nandi should be liable because they did not interfere with the repayment.
Thank you.
Thank you.
Your Honor, if I may paraphrase, I think what counsel just said is that it was okay to steal the money. It's just okay. They can borrow money from a funder. They can take it, they could use it to pay Reena Nandi's mortgage, Reena Nandi's taxes, Reena Nandi's car payments, gym memberships. They can give the money to pay pay college tuition for Reena Nandi's children, and it's okay. That's not okay. I would implore the court because we don't have time, I would implore the court to just look at pages 6 through 8 of my reply brief, where I talk about, and this response to Your Honor's question, the domination is not just the lack of formalities or just the fact that she signed all the loan documents. It's a combination. She was 100% shareholder, signed the promissory notes, the security agreements, every single document, and combine that with a total lack of corporate formalities, you've got domination and control, and then they took the money for their personal use. Thank you, Your Honor. Thank you.
Greenage versus Steele.
I have a rebuttal, Your Honor. I'm sorry.
Oh, I'm sorry.
Thank you.
You have
So,
1 minute.
I'll be very quick. First of all, my clients did dispute that the monies that were borrowed were all used for personal expenses. If you look at record 3629, we point out that the money...
I don't see what difference that makes, since none of the money was supposed to be used for personal items.
Your Honor, and I would respectfully submit that in do-gooder, this court specifically ruled the evidence is insufficient to prove defendant's wrongdoing in utilizing the funds for his personal use. So merely because some of the funds are alleged to have been used for personal use, and I submit to you, under 3629 of the record, we dispute that. It is disputed. But even if it were true under this court's decision in do-gooder, it's not enough. There has to be some showing that the alleged use of personal funds interfered with the repayment, and I respectfully submit that there is not a single case in the history of the state of New York where someone was able to say it was used for personal expenses and that's enough. It has to be shown that the use of personal expenses interfered with repayment, and I respectfully, again, refer you to Ricardo. There was no...
Thank you.
Can I give you one citation?
No more.
Thank you, Your Honor.
Thank you very much.
Greenage versus Steele. You may proceed.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant respondent. On this case, we are appealing the apportionment of fault, and we're appealing the $250,000 total pain and suffering
Was
award.
your client in the crosswalk when she was struck?
She claims she was in the crosswalk.
Well, isn't there a dispute about that? Isn't that an issue of fact that the jury decide? And if the jury found that she was outside the crosswalk, couldn't there be comparative negligence under those circumstances?
Yes, Your Honor, there can, except we feel 35% is high for this reason. Because even if it's unclear if the jury found that she's 2 feet outside the crosswalk, like she said her son was pulling her, or they believe part of defendant's testimony that she was where he was, 3 cars back. But either way, he's at a stop position. He leaves a stop position and he moves forward and hits her. So I still don't know how the 35% is not against the weight of the evidence, because he wasn't moving. So even if under the charge of 1152, where a pedestrian crossing a roadway outside the crosswalk has to yield, they're required to do that where it's likely for the motorist to strike her. And it's our position that because he was stopped and moved forward and hit her, 35% is against the weight of the evidence. With regard to the $250,000, plaintiff sustained, as you know, 2 tears of the ACL, 2 arthroscopic surgeries, 2 herniated discs, 1 in the cervical spine, 1 in the lumbar spine. She had 2 arthroscopic surgeries.
The experts have a dispute with respect to, for example, permanency. Did each expert take different positions on that?
I believe so. I believe the defendant's...
So then why couldn't the jury in this instance find, in fact, that there wasn't a permanency, it was something else?
Well, I believe that in this case, that they found a significant limitation. They didn't find a permanent consequential. The defendant's position, it's all degenerative. I believe that the jury disregarded that or did not believe that because they found a significant limitation of use. And in this case, in 2023, at the time of the trial, plaintiff's experts, Dr. Berkowitz, who's the knee surgeon, finds decreased range of motion in 2023, finds it permanently disabled, and says that she's going to likely need future knee surgery, maybe a knee replacement. With regard to the spine, Dr. Latuga I'm sorry?
Couldn't the jury reject those claims? I mean, because the eyewitness testified, I think, that was Ms. Saunders, that it was a light tap, correct?
Yes.
So couldn't the jury reject the claims you're making with respect to subsequent treatment?
They could have, except...
And was there an evidentiary basis for that?
I don't think so, based on her condition at the time of trial.
How about the light tap? That there was just a light tap, and so there was no causal connection between.
Well, they did find a causal connection because they awarded my client money and they found that he was negligent. I think the light tap is still by an automobile, and I think Dr. Berkowitz explained that it's the force of her falling on her knee that really was what caused the injury to the extent it did. Not so much if she's just tapped, it's the force and the gravity of her falling on her knee. In addition, she's 9 months pregnant. So that is why I think that, again, in 2023, she's still in bad shape. There's testimony that she needs future surgery. There's decreased range of motion. And he says, and both surgeons say that she's permanently disabled and nothing's going to help her except future surgery. So that's why, under the case law, which is in our brief, and you know that 125 for past and 125 for future, I can get to is extremely low. And with regard to the future pain and suffering of 10 years, our position is that that is inadequate because that puts her at 42 years old, and she's likely to have a knee surgery and a back surgery. And so that's only 10 years, where the life expectancy table, which you don't have to go to the exact degree of it, has her at, I think it's 48.6 life expectancy that the jury was charged. So we feel that the 10 years is against the weight of the evidence. There's no support in the record to reduce her life expectancy as a 10-year future pain and suffering. So I still have time, which is crazy. I guess I can keep going because I just didn't think I could. One last thing before my light changes is that, in addition, and to answer your question, I think that the plaintiff's testimony is really what makes the value so low. I mean, it's just not just about being tapped. Did you fall? The car wasn't moving. It's the pain that she has, the discomfort, the knee locking, the fact that Her life
What
is.
about what she reported when she went to the emergency room? Isn't that a part of what the jury considered?
I think so, and I think the jury considered it, and I think that. Can I finish?
Yes.
Sure. Okay. Sure. I think that the focus, as she describes, was on whether her baby was okay, and the fact that she first sought treatment several months later after nursing also goes to what her priority was at the time. I just don't think it's contested that she sustained the injury she did based on the plaintiff's experts.
Thank you.
I'll take the rest on reply. Thank you.
You may proceed.
May it please the court, Payne Tadich for the defendants, respondents, appellants. As this court is aware, the jury verdict is sacrosanct, and their determination of the facts and their evaluation of the credibility is entitled to deference by this court. Counsel has...
Defendants only argue that when they get a low number on a jury verdict. But go ahead.
No opinion on that, Your Honor. Various honors, you've correctly pointed out that there was a lot of varying testimony here. Plaintiff actually conceded that she was outside of the crosswalk. The statute applies to any point outside of the crosswalk. That's the explicit language in 1152. And none of the cases they cited for their argument that she must be mid-block say that you have to be mid-block. But plaintiff admitted she was outside the crosswalk. There's a dispute as to whether she was 3 feet out of the crosswalk or 2 to 3 car lengths outside the crosswalk. But the jury was entitled to accept any portion of a witness's testimony that it rejected and that which it believed. They don't have to take everything all or nothing, as plaintiffs have argued. There was also testimony on the negligence point that the light was green at the time of the accident. That was Mr. Steele's testimony, and on cross-examination, plaintiff was asked what was the color of the light. She said, I don't know. And that was a 314 for her admission on that. So I think there was plenty of evidence for the jury to say Mr. Steele bore the majority of the fault here, but plaintiff also was partially at fault. With regards to what the experts said, this is what you were talking about earlier, Justice Manzanet. This was a battle of the experts, and you had experts that were saying different things. Some were saying that plaintiff's experts were saying she's permanently injured, she's going to have all these future surgeries. But the jury came back, and this is 2238 in the record. They answered no on the permanent consequential limitation. They did find a significant limitation. We're not challenging that here, but that includes a non-permanent, non-total injury. And when you couple that with, it was a light force that she was tapped when she was hit. She went to the ER, diagnosed with a scratch on her knee, and then she left on her own accord. She seeks a
Yes, but come on. She was 9 months pregnant. A woman who's 9 months pregnant and just got hit by a car, there's only one thing she's worried about at that ER, and that's the baby. So say what you want. I can accept all the other stuff, just the scratch on the knee, but the fact that her focus was not on her knees and was on her baby is of no surprise to me.
Your Honor, I'm also not surprised by it at all.
Okay.
So I understand that completely, and I feel the same.
Glad to hear you say that.
No, that is not in dispute. But what I think we know that the jury believed, and that's really what the issue here is that she wasn't as injured as she claimed. They found she was injured, but when plaintiff's counsel asked for $3.9 million in total pain and suffering, they gave her a fraction of that. And I think the evidence of what happened at the hospital, evidence that her knees actually were degenerative and they had a patellar congenital condition, which plaintiff's experts actually conceded. Dr. Berkowitz, who was talking about her spine, well, there's the same neurosurgeon in his office who said she has degenerative disc disorder. So I think you combine those things, and that explains why you have this pain and suffering award. And speaking of plaintiff now, she no longer takes any medication. She hasn't seen Dr. Berkowitz for 8 years and Dr. Latuga for 5 years before trial. She went back to school. She got a bachelor's degree. She's working on her master's degree. She takes care of 2 children. She goes grocery shopping, laundry. I mean, she is doing a lot. And I think that explains partially, if you combine that with the, they didn't find permanent, that explains why they gave the 10 years of future pain and suffering, because the lingering pain that she has would resolve with some conservative treatment, physical therapy. Briefly, because I know that my time is almost up, we had a very limited appeal on the future medical expenses, which is a different standard of reasonable certainty. Dr. Latuga, who is the expert they used to establish the back and neck surgeries, He said on direct examination, she's going to need this. But when he was pressed on cross-examination and he was asked, can you say that she's going to need this neck surgery? Well, I can't answer that question yes or no. And this is A512 in the record. He said the same thing with the lumbar. And when you take that in consideration with the gap in her treatment, the fact that she hadn't seen Latuga since 2018, and then once right before trial. She hadn't seen Berkowitz since 2015. Then she saw him the month before trial. I think if you combine all of that with his equivocation and his retraction, which they never actually addressed on redirect, so this is the last word that the jury had, I think that the future pain and suffering wasn't established with reasonable
Why shouldn't
certainty.
we defer to the jury on that, as you asked that we defer on some of the other issues in the case?
I think the main difference is just the standard, the reasonable certainty standard needing to be competent medical proof. And then because the jury came back with their verdict, as they did on the pain and suffering, plaintiff's burden is a little different, showing that the evidence so preponderated in their favor that there was no fair interpretation of the evidence. Thank you.
Just with regard to the values, the defendant's position, this was just degenerative. They didn't, I mean, I understand that she stopped treating. She only treated with her spine surgeon for 4 years and Dr. Berkowitz for 2 years. But at the time of trial, the injury, not only had it not gotten better, the doctors claimed her to be disabled and she needed future surgery.
It was a disputed issue of fact at trial. The defendant's doctor said it's degenerative, it's genetic, and your experts testified it was trauma-induced. The jury made a decision on that, correct?
Correct.
So how do we get around that?
Because even if it's genetic, like the genetic defects that she had in the patella, and if there was any degeneration, which by the way, in the L spine, you can see it at the MRI of L spine at 1096 of the record, it doesn't say degeneration. And on cross-examination, it was the plaintiff's expert explained that desiccation is drying of the discs, which happened from a herniation. This MRI report doesn't say degeneration. But again, the jury heard what the jury heard. In any event, even if it's degeneration, and even if there's a genetic component to the knee, if it's asymptomatic or something's latent and something's exacerbated by the accident, there's still not a question that they're responsible for, but it still doesn't take away from the extent of the injury and what will be caused in the future by the negligence or by the negligence of the defendant. So,
You want to address?
oh yeah, sure, quickly. Yes, the award for future medical expenses is amply support. I'm sorry, well, you can.
How are they shown with medical certainty?
I'm sorry.
How are they shown with medical certainty?
Well, because the Dr. Berkowitz and it was Dr. Latuga testified that she may need a revision surgery for her cervical, her C-spine, because sometimes it affects the other level, and that's $100,000 that he estimated it to be, and that she would need future. She hadn't had surgery on her lumbar spine yet, but he believed that she would, and that would be $100,000. That's at 486 to 487 of the record. So I would imagine that's where the jury gets the $200,000 for. And we find it's ample support.
Thank you.
Thank you.
Just real briefly, with regard to the lumbar surgery, counsel said she hasn't had the surgery yet. It's been 10 years. 11 now at this point, but it was 10 years at trial. So I don't believe that they established with reasonable certainty that she's going to have one more than 10 years after the fact.
She's a young woman, isn't she?
She is a young woman, Your Honor. She was.
And she's taking care of 2 kids, right? 2
Yeah.
little kids?
Oh,
So back surgery is exactly what she needs to go running around 2 little kids. But go ahead.
No, she is an amazing woman. She was 22 at the time of the accident, 32 at the time of trial, takes care of 2 kids, went back to school. There's no doubt about that. I just don't believe that if she didn't have the lumbar surgery in the first 10 years, given Latuga's retraction on cross-examination of, well, I can't say yes or no that she's going to have it, that they established with reasonable certainty. And then with regards to...
What did the plaintiff testify about that?
She, at one point, said, I'm going to have back surgery, which of course wouldn't be her opinion because she would be told that by, so.
So why couldn't the jury make a credibility finding, believing that in fact that she's going to have the surgery?
Well, I think that the reasonable certainty needs to be established with competent medical proof by a medical expert, not by plaintiff saying, I'm going to need the surgery. And again, she hadn't seen Berkowitz in 5 years, and Berkowitz in 8 years, and she hadn't seen Dr. Latuga. And I would just point out the Hyatt v. Metro North case that's cited in our brief. When there's a gap in the treatment combined with a doctor who gives a less than reasonably certain answer, that's not enough to establish future medical expenses.
Thank you. Haruvi versus Hungerford. You may proceed.
May it please the court, David Fine on behalf of Michelle Haruvi. In addition to addressing any questions the court has, I'd like to focus on three overarching ways in which the trial court erred and rely on our briefs for the remainder. The trial court's first error was in holding that the requirements of BCL Section 909 were not implicated here. That is simply not so. Simri Realty transferred its entire real estate portfolio to a group of newly created LLCs.
Well, can I interrupt you for a minute? What does BCL 909 focus on? Does it focus on the change to shareholder status, or does it require the trial court and us to analyze whether there's been a change to the corporate status?
Your Honor, I think what the statute is looking at is whether, if you take a look at all of the assets of the corporation.
So it's the latter, is what you're saying?
It's the corporation, right. Whether the corporation has transferred, conveyed, made disposition of all or substantially all of its assets.
And in this instance, the trials court focused more on shareholder status or corporate status, in your view?
I think the trial court focused on both. I think it just did it incorrectly. The trial court, for example, said this was just a reorganization, which it wasn't, of course, because 7 new LLCs were created for these apartment buildings to be deposited with. And in addition, there was substantial change in the disposition of the property. But even if it were just a reorganization, however the trial judge understood that to mean, it doesn't matter. The plain language of the statute says that if you disposition of all or substantially all of your assets, which clearly happened here, at the beginning, Simri Realty had 7 apartment buildings. Those were its assets. At the end, after May 13, 2022, it had none of those things.
They had an interest in a company that owned the assets.
That's right, a 10% interest, Your
Right.
Honor. So a very diluted interest and a very attenuated interest. And it was clearly not, and this is the second error that the trial court made, it clearly was not within the regular business of Simri Realty to sell all of its assets. Number one, the trial
They managed and rented space, right?
That's right.
That was their business.
Well, and owning the property, Your Honor,
Right.
but I agree with you, absolutely. So then the trial judge focused on, for example, what the certificate of incorporation said. Well, we know from authority from this court that that's not the point. It's what was actually done. And actually, in the history of this company, there was something like 1 sale of real estate going back a half a century. So that was an error. The last point that I'll focus on, given the timing, is that the judge found that there was no problem with the lack of notice because my client somehow had knowledge. But if you look at what the trial judge said she had knowledge of, not one of them was the transfer of those apartment buildings. And that's the issue that triggers Section 909. So number one, he shouldn't have been making credibility determinations anyway. But even
in any way wasn't, in any event, was not in any formal way. It sounded more like it was at a conversation between family members.
he looked at email messages and text messages, and notwithstanding the fact that she put in an affidavit that said, I did not know in advance that these buildings were going to be conveyed, he said, you knew these things, and that's enough. Not one of them was knowledge of the anticipated conveyance. The actual trigger for Section 909. So he erred in all three of those ways. The last thing that I'd like to mention just very briefly is on the rescission point. My opponent says, well, there's a money remedy, so therefore rescission isn't available. That's a good rule at common law, but this is a statutory claim. And this court and other departments of the appellate division have said that if 909 is implicated and not complied with, then the transaction is void. Not voidable, but void. For all of those reasons, Your Honors, Michelle Haruvi asks that this court reverse the decision of the court below, reinstate the notices of pendency, and remand the case for further proceedings.
Thank you.
Thank you.
Good afternoon, Your Honor. It's Brian Gardner of Cole Shots for the respondents. Your Honors, Judge Barak got it exactly right. 909 was not enacted for a situation where a family-owned, closely owned business dropped down its...
Where in the BCL Section 909 does it make an exception for family-owned businesses?
It doesn't, but
Okay.
but it means...
So then it applies to all businesses by the letter of the law. So explain to me why the letter of the law, under that section, on these facts, isn't exactly as your adversary says.
Because you have to, because as Judge Barak found, everything else started with, in his opinion, and then it went into these other issues. What Judge Barak found is this, at the outset and then repeatedly, this was not a transfer of all or substantially all of
What was not transferred?
Well,
Since you're saying not all or substantially
Right.
all of this company's assets were not transferred,
Right.
what wasn't
It was not
transferred?
a disposition because...
What wasn't transferred? What asset was not transferred?
10%, Your Honor, and 100...
No. They transferred all of the 7 buildings. What the plaintiffs have here is 10% of interest in the ownership of the new company that has these buildings. That is not 10% of the assets,
It is 10% of the...
of an interest in an asset.
Indirect.
It's not an asset.
Well, it is an asset, Your Honor. An
It's an
indirect-
interest in assets.
Right.
The asset was the building.
Okay.
So which building didn't get sold?
They all got... nothing got sold. They got...
Everything
transferred
got
in a
sold.
reorganization. There was no...
No, there was no reorganization. This is a new LLC.
But into special... There was a refinancing. These are undisputed facts. There was no credibility determination. There was a large refinancing to take out one of the brothers, right? And to do that, they restructured by dropping down the entities into single-purpose entities where the SIMRI entity still owned 10% of now that holding entity and 100% of the common stock. So there was no sale of interest in anything. They just reorganized to do a refinancing and buy out the one brother. And that's all that happened. There was no
But the net
money
effect,
sale.
the net effect is Simray no longer owns 7 buildings that it's been owning and managing for many, many years, correct? So there has been most decidedly a transfer.
There was a transfer, but it still has an indirect ownership in those buildings,
Indirect ownership in what percent?
in the holding company of those buildings. They were only dropped down to the special purpose entities so that the refinancing could occur, which is just a restructuring. These were not a sale. This was only for that purpose. SIMRI still had valuable assets. The case law talks about disposition of all assets. The case law repeatedly talks about liquidation.
And I still haven't heard from you what asset was
Well,
retained.
SIMRI was not liquidated. SIMRI is still an ongoing
Well,
company.
Simray is still, is a shell, essentially an
It's
empty
not
shell.
a shell. It owns 10% of a very valuable and 100% of preferred of a very valuable asset.
But before this transaction, there were 7 properties in Simray. It no longer owns that. So clearly there was a disposition of those assets.
There was a disposition, but a retaining of an interest. The case law talks about dissolving or liquidation. 909 is to prevent a dissolution or a dissolving of an entity. SIMRI still has a lot of value in it.
Can I turn to a different part of 909? I didn't see anything in the record that shows any kind of formal notification of plaintiff of what the actual, whether it was a restructuring or a sale. There was no formal notification to her of the series of events that you've now described. Can you show me where there is such a thing?
Well, there was notice of, and there's a lot of notice, again,
No, there were emails from various people to her, but was there any formal notice that we're going to do this and then pay off him, and we're going to move all of these, all of the properties into a holding company and so on? Was there anything like that? I didn't see it.
there were documents provided to her to the extent that she reached out to the brother who was being, bought out by the refinancing to say, why don't you not be bought out? and
Let me
we'll
ask
stay
it
in
a different
control."
way. If I'm right that there's no notice in the record that formally shows that she was given notice of what was going to happen,
Right.
do you have a problem? Does that mean that you're liable under 909?
If it was a sale of all or substantially all of the assets, and that was beyond the ordinary course of the sale.
And the notice would be an essential element of that.
Which Judge Brock found that this was not a sale, correctly found it was not a sale because SIMRI was not dissolved or liquidated. It still
That's why
maintained-
we're here, to decide exactly
Yes,
that.
Your Honor.
Thank you.
Can I speak to rescission or not? The rescission,
You're out of time, but I'm going to give you 30 seconds.
Your Honor.
So no one says I'm mean. Go ahead, 30 seconds.
well, the Court of Appeals has repeatedly
You're going
said,
to say it anyway, but go ahead.
there's no 909 decision that says, while some courts use the language void, there's no 909 court that says it should be rescinded. The Court of Appeals has said to do rescission, which is their first cause of action, you would need to be able to put the parties back where they were at the beginning. The status quo ante needs to be restored, and money damages are not available. They plead money damages are available, and they cannot say that the status quo ante can occur.
Thank you.
Thank you, Your Honor.
You have 2 minutes on rebuttal.
Thank you, Your Honor. I'll try to make this very brief, and of course, want to answer any questions the court has. The language from other departments that talks about liquidation says liquidated or partially liquidated. So whatever liquidated means in those cases, it could just as easily apply here. But back to Judge Manson.
What are you claiming here? Are you claiming a liquidation, or it's just essentially it's a transfer of assets from SIMRI to another corporation?
Your Honor, I'm pointing to the text of the statute. And the text of the statute says disposition, sale, transfer, all of those things. Here, there was clearly a disposition of all of the assets. And my opponent, when Judge Manson at Daniels asked, what assets remained, couldn't come up with any because there weren't any. It was all of the assets. Now, on the question, Your Honor, that you asked about the notice, there was no notice. There will be nothing in the record that will say that there was an official notice. My opponent essentially conceded in response to your question that this notion that Justice Borak used of, well, she knew anyway, doesn't work because you asked him.
The fact that this is a closely held corporation, does that have an impact on the formality that's required with regards to the notice?
It does not, Your Honor, especially not with respect to the notice issue. There is one case that I'm aware of that said, well, closely held, if you sit around the table and you say, hey, is everybody good with this, that maybe that's okay. But no case has said that the notice is dispensed with, which makes perfect sense. Michelle Haruvi was denied the opportunity to have a say, to try to persuade people to vote against. Remember, there has to be a supermajority under 909. She was denied the opportunity to do that. The final point that I'll make is my opponent talks about the rescission point. And the bottom line is that this court and others have said it's void ab initio. The only way to do that is through rescission. They say in their brief something about, well, you can't restore the status quo ante, but the record doesn't address that. So that's not for this court. If there's an argument to be made, it's for the Supreme Court on remand. Again, we ask the court to remand, to reinstate the notices of pendency, and to remand, and then to remand the case.
Thank you.
Thank you, Your Honors.
People versus Giapan. You may proceed.
Good afternoon. May it please the court, Lena Janota on behalf of Appellant Giapan. Today, we respectfully request that this court accept the respondent's concessions and remit this case for resentencing. I wanted to appear in case the court had any additional questions.
Is there, I thought that the initial motion was to vacate the plea.
That was one of our requests, yes.
Are you abandoning that request?
No, but given that the respondent has conceded that the correct remedy here is remittal for resentencing, at that, with resentencing with new counsel, at that time, Mr. Pan will have the right to move for plea withdrawal, and that is really the
Wasn't there a motion already for plea withdrawal?
Yes.
Okay, and that was denied, right?
But that was post denial of his Sixth Amendment rights, which the respondent has conceded. So he pled guilty, appeared in court and he appeared in court again with newly retained counsel, and he asked the court to allow him to proceed with his new attorney. The court denied that, and the respondent, to their credit, has conceded that that was an error. That was a deprivation of his Sixth Amendment right. Respondent has also conceded that there was a conflict of interest. So given those two...
But why wouldn't those two factors then infect the validity of the plea itself?
It's certainly our position that it does. But given that the respondent has conceded that the correct remedy here is for remittal, the
Right, but
proper
the question
place...
is remittal in what context? Remittal to start over with new counsel, or remittal to argue to the judge below to vacate the plea? I thought that had already been denied, and that your appeal was to reverse that decision.
Well, it's certainly... So if this court were to grant what we're on the same page about it here, it's that Mr. Penn would be allowed to go back for resentencing with new counsel and move for a plea withdrawal with unconflicted counsel.
So you're asking us now to vacate the sentence as opposed to vacating the plea?
That's correct, because again, if
just so that I'm crystal clear, you're not asking us to vacate the plea.
Initially, we were asking...
What are you asking today?
Why have you withdrawn that?
We're not withdrawing. It's absolutely our position that this plea should be vacated. However, this court has a limited...
So why are you not asking for that?
Because this court has a limited record.
The fact that your adversary realizes that there's a problem here, I don't see how that changes your position.
So perhaps I should clarify. The respondent is conceding 3 issues. 2 of those are...
They're conceding everything. What they're saying is send it back for resentencing, right? Which we thought was materially different from your position, which is this whole thing, the whole plea was infected, therefore vacate the plea. They're 2 very different things, remanding for vacating the plea and remanding vacating the sentence. What are you asking for?
It was our position that the plea should be vacated because he there was ineffective assistance of counsel because he was misadvised about the immigration consequences.
Is that still your position today?
Absolutely. However, the respondent is conceded that he was misadvised, but is arguing that there can be no prejudice found. And what our position is that if this case was remitted to lower court, Mr. Pan would be able to make these plea withdrawal arguments and
I need you to listen to what you're saying.
Yes.
Okay? Right? And listen to the court's questions. Okay? So you asked in your papers to vacate the plea and send it back for new counsel and consistent with that vacature.
Yes.
Your adversary acknowledges that there was a serious ineffective assistance of counsel problem, and so has agreed this should go back, but they suggest that there is a need for a prejudice hearing. Is there a need for a prejudice hearing on this plea?
Certainly not our position, no.
Okay, so if there's no need for a prejudice hearing, then the only thing that you could possibly ask for is to vacate the plea and send it back for new counsel and to proceed.
That's correct.
Okay. All right, thank you.
Thank you.
Counsel. Since your position has been stated several times, why don't you tell us what your position is and what you think we should do?
Yes, Your Honor. Good afternoon. May I please support Faith Petrolia for the people? Our position, I believe, matches the one that counsel just discussed. Basically, we are conceding to the right to counsel issues, and it is our position that that means that this case should be sent back for resentencing with counsel.
I see no, so speaking only for myself, I'm sorry, speaking only for myself. This client, this defendant, had an attorney who submitted papers saying, My client's story is not supported by the evidence. How is that, under any analysis, subject to a non-prejudicial assessment?
Well, it's my understanding that counsel is arguing for.
No, I want to know what you're arguing, because we went back and forth on what she's arguing.
I understand, Your Honor. It is my understanding that the prejudice hearing would be on the Padilla issue in this case.
On the what?
The Padilla issue in this case.
Only the Padilla issue? There were so many things that were offensive that happened here.
Well, is it that you guys have agreed that if we send it back for resentencing, then he can get the attorney that he initially wanted, and that attorney will represent him in trial court? So you guys all came to that agreement?
Yes,
and that's what you guys really are after, right? Having that specific attorney assigned and representing the defendant for resentencing.
Yes, Your Honor.
But you don't agree that the plea should be vacated. You think that the plea that was taken in this case with an attorney who made statements that I quite frankly cannot comprehend how an attorney does that to his own client. Okay? So I don't understand how this plea could stand.
Because
it offends every single aspect of the Sixth Amendment, as far as I'm concerned.
Because the focus that the two of you have placed is on who the attorney is and not necessarily what happened with the plea or vacating the plea.
It's our position, Your Honor, that this ineffective assistance and this deprivation of the right to counsel occurred at sentencing, because that is when defendant...
Oh, it happened before sentencing. It happened at the plea.
Counsel, we have here a case where the defense attorney orally makes representations to the court and in writing that basically that the defendant's defense is not viable, right? That is claiming an interest against the client. And then in addition to that, we have a advisement on the Padilla issues, right? This is one of those cases where the defendant will be deported, or at least it is extremely likely, in which case the advice needs to be you're going to be deported. That didn't happen. I don't understand that, given all that, how one could come to the conclusion other than the defendant was prejudiced in his determination to plead guilty.
Yes, Your Honor, and I think we did concede that counsel's advice was misadvice under this court's precedent in Johnson. I would just add that defendant will have the opportunity to withdraw his plea at his resentencing if he wishes to do so.
Under your theory, under your agreement, what it appears, the discussion you've had is that he would have the right to request that his plea be vacated, not that it be vacated.
Correct.
Because what you guys aren't saying is that he wants the plea. He just wants the plea with the lawyer that he wants the plea with.
I'm sorry, Your Honor.
You would have no way of knowing that.
Counsel and I have not discussed this case outside of briefing. We have not come to a separate agreement.
But you also have not come to a separate agreement that if we just send it back as you have suggested, that the people are going to consent to the vacating of the plea. The people have no intention of consenting to vacating the plea. Correct?
I have no knowledge.
I would imagine
but I would imagine
your goal, if we send it back for prejudice hearings, to say that he was not prejudiced.
Exactly.
On the Padilla issue, correct.
But that's not the only issue.
Yes.
So you're saying that the other issue where his lawyer
under the bus.
Yeah, I mean, I'm trying to be careful about what I say. It is the most offensive record a defense attorney I have ever seen in this court. Never have I seen a defense attorney throw their client under the bus before a sentence. So I don't understand how there's anything this court can do other than vacate this sentence, this plea, and send it back.
I understand, Your Honor. Our position is that defendant can make that motion at his resentencing if there are no further questions.
All right.
Thank you.
Well, you had no rebuttal
Didn't
time.
request any, but may I briefly make...
Yes, I'll give you 30 seconds.
It is absolutely our request that this plea be vacated. I'm sorry if I didn't make that clear from the outset. Thank you.
Thank you. Barros versus Bonos. And I know I messed up that last name, and I'm sorry.
You never mess anything up, Judge.
Well, thank you. I'm gonna hold you to that. Go ahead, you have 3 minutes.
Thank you, Judge. If it may please the court, my name is Jimmy Wagner. I'm for the appellant defendant, Bonos 243. The issues in this case are very simple. This pre-answer motion was denied for failure to state a cause of action and on statute of limitations. While the lower court and in the briefs, we focus a lot on the statute of limitations for a rent overcharge, I want to refocus our attention to the statute of limitations for a declaratory judgment. Because before we can get to the rent overcharge, before we can get to anything, we have a 6-year statute of limitations to unregulate for the plaintiffs here to regulate this unregulated apartment. Both apartments in this instance had been deregulated since 2017. The landlord in this instance properly filed his DHCR records for the last 18 years. My client was a good faith purchaser in 2022 for $3.5 million. He relied on those DHCR certified records, which in fact there's never been a claim. These tenants have been in that apartment since 2007 and 2009, waited until 6 months after my client purchases this property to make a claim for rent overcharge. If we look at the entire amended complaint, there is absolutely not a claim for fraud. There's not a claim that my client did anything wrong. And essentially, the lower court...
Is the law, or under the rent stabilization law, can a successor owner be responsible for its predecessor's fraud?
So under rent stabilization law, if in fact this was a regulated apartment, I would say there is instances where they could be.
But in this instance, the claim is that the IAIs were fraudulent by the predecessor landlord, and it was a rent-regulated apartment. So why isn't that a viable claim here?
Because the idea that we say something is a fraud isn't a fraud in and of itself. There is not any attempt here to make a claim for fraud. If we actually look at the complaint, there's only 5 claims, and none of them are for fraud at all. The claim is for a declaratory
The claim,
judgment.
as I understand it, there's a contractor affidavit, Mr. Leahy, who says that no work or no major work was performed in these apartments. Now that sounds like maybe they don't use the magic word, but it sounds that they're alleging some form of fraud.
But that is a tremendous leap to... You're right, there is no magic words here. There's no implied fraud. But it's even a tremendous leap to say just because 18 years ago, this person today in 2024 is saying that repairs weren't made. That is not the only reason why somebody's in a rent-regulated property, the rent can go up. It's not just strictly based on repairs. We have rental increases from vacancy increase, different exemptions. Any further questions? I see the red lights on.
No? Okay. You'll have time on rebuttal.
May it please the court, William Levitt for the respondents. I should first note that 2 of the 4 apartments at issue have dropped out of the case recently because there was a settlement with the landlord. So 3 of the 5 tenants.
What are you claiming here, counsel?
We're claiming, first of all, there's 4 causes of action. The first 2 are not rent overcharge, therefore determination of the regulatory status of the apartment. That's with a declaratory judgment clause.
Is that subject to a statute of limitations?
No, it is not. It is not.
Why is that?
Because this is under the Regina case, they specifically exempted status determinations from the statute of the 4-year look-back statute of limitations that existed before 2019. So I don't know of any case that disputes that. A status determination is not subject. This is not a question you don't even need to show fraud, okay? We are showing fraud.
Well, you don't, but your adversary says you don't use the word.
We do in our prayer for relief in our amended complaint under rent overcharge. We say there is a two-step fraudulent deregulation scheme, where maybe it's two-step or a three-step, because it takes place in only a few years, like 2 or 3 years. Vacancy improvement. Then the next year, vacancy improvement. And then the next year, vacancy deregulation. So each time there's a vacancy improvement, the landlord puffs up the amount of renovations that are done to the apartment. In this case, the inspector or the expert finds that there was very little minor renovations when in one apartment they needed 33,000 of renovations, and in the other apartment they needed 28,000. So the burden should shift to the landlord, explain what's going on here. The landlord has never volunteered to give us any proof of the renovations. Often in litigation, the landlord will immediately show his cards, but here the landlord is not showing anything. It's the prior landlord, by the way, so maybe the landlord has no proof of any renovations. We don't know that. We need to get into discovery to determine, does the landlord have any proof at all of these renovations? So
Counsel, you're going to have to finish up. You're out of time. I'll give you 30 seconds.
This year, as has already been discussed in a prior case, the chapter amendments, Chapter 95, have totally changed in an attempt to overrule this court in the borough's decision that we no longer should be using common law fraud principles. This is a regulatory fraud situation like securities fraud.
Thank you.
Or consumer fraud. This is not common law fraud. Thank you.
Thank you. You have 1 minute on rebuttal.
Thank you. In reference to anything that should be turned over or not turned over in discovery, this is a pre-answer motion. We haven't even engaged in that, so that's just, the court should not consider any of those statements.
So you heard your adversary. He says that in his prayer for relief, there is an allegation of fraud. So you're on notice that they're alleging a fraud to deregulate.
In the prayer for relief, it's related to the overcharge. I've read the entire Regina case. The idea that Regina says, you know what,
so have we many times.
As a practicing attorney, I will be very happy to know that in regulatory instances, there'll be no more statute of limitations. Trust me, first thing I do in any case is I look at the statute of limitations. Counsel would have you believe that the Court of Appeals, that this case and the statute itself says, when it comes to rent deregulation and rent regulation, there is no statute of limitations. These parties, mind you, these two remaining tenants have lived in this apartment for the last 18 years.
Thank you. Quinn Emanuel versus Avra Surgical. You may proceed.
May it please the court, Andrew Goldenberg for appellant. Your Honors, I'd like to start with whether or not this appeal can be reviewed. We have an alter ego order, a prior order, and a judgment. They're both subject to appellate review. The prior order deemed the appellant an alter ego of the debtor here, Avra Robotics. The judgment decision relied entirely on that prior order to make the same determination that Mr. Stammel was an alter ego. The only basis for the judgment is the finding of alter ego. The prior order is a non-final order. It was before your court. This court determined that it was not appealable because it was based on a motion for re-argument or a motion to resettle or clarification. So we have a non-final order, and without that prior order, the judgment could not have been sustained and would have required to be vacated because it's entirely based on the prior order. So we have CPLR 5501, which allows for the prior order that necessarily affected the subsequent judgment to be both reviewed, both the prior order and the judgment order. And in opposition, there's not one mention of 5501 in respondent's brief. They've conceded this point, so you can review it. But if I can go a little further, you'll see this argument in opposition. Well, they didn't raise the issue, appellant didn't raise the issue of alter ego in moving to dismiss the petition. The affirmation submitted in the motion, the opening brief, says, I quote, "I deny QE allegations it makes on information belief that Surgical and I are alter egos, that I dominated and controlled Surgical, that I wrongfully transferred unidentified assets from Surgical to this other company, Avra Medical." This is on page 140. We have other sworn statements in the affirmation. So we didn't waive anything, but even if you want to entertain this waiver argument, we have 5501. So it can be reviewed. Now I want to switch over to the main event.
On the merits.
Yes.
On the merits.
Thank you.
Exactly. But let's switch over to the main event, okay? The main event, this is an interesting thing that I've never seen before. We have a lower court that's determined that you can hold someone personally liable as an alter ego based on a connection. And this connection is that person, in this case, was a lawyer of the company, was a shareholder of the company, was an officer of the company. But as Judge Singh said in a prior case today, there's nothing wrong with holding roles in a company. It doesn't make you personally liable. You got to do something more than that. It can't be a sufficient connection. I've never seen a case like this before.
So let's just get to that. Has petitioner shown that your client completely dominated the Avra entities and used that domination to commit a fraud or injustice?
Yeah, so let's talk about it. Where's the domination control? Because you hold different roles in a company, that means you've dominated and controlled it? There's nothing in the petition, no evidence to support that. But let's assume there's domination control. Where's the wrong or the fraud? You don't have to prove fraud, but where's the wrong?
Are there any allegations of fraudulent transfers, for example?
No, they're seeking to hold appellant liable for fraudulent transfers, but there's no specific allegations in the complaint about $1 that was transferred from the debtor to appellant. There's nothing. And in fact, the lower court held, this is on page 296, 297, that the petitioner failed to meet its burden of establishing the existence of any transfers, fraudulent or otherwise, from the debtor to the appellant.
Now, appellant does argue that there were transfers, but that he didn't do them and he was a victim of those transfers, right?
The appellant doesn't, no, the appellant just says, I didn't transfer any money, but I didn't receive, I'm not the...
Well, money was stripped from the company. I think
That's what is alleged, Your Honor, but we don't actually even know that. So the only sworn testimony that's been provided in this case has been from the appellant, who said that the debtor had a subsidiary company. That subsidiary company appropriated $4.5 million. It was run by this gentleman named Bern Gombert, and that Bern Gombert took the money and ran. And that's what we've submitted. Now, what we have on the other side are unsworn, unverified allegations, all based on information and belief that the appellant is the recipient of fraudulent funds. We don't know the amount. We don't know when he received them. We don't know anything. Why don't we know anything? There's no discovery. No discovery was taken. We have a veil-piercing analysis. It's fact-intensive. No discoveries taken. We have material issues of fact that require under CPLR 409B that a trial be conducted in this special proceeding. We don't have that either. So at the very least, let's assume you accept all the allegations on information and belief, which I submit should have been dismissed in the first place. At the very least, this case should be remanded, there should be discovery, and there should be a trial. Because you can't hold someone personally liable because they happen to be the company's attorney.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Geneva McDaniel, and I represent Quinn, Emanuel, Urquhart, and Sullivan. This Court should affirm the lower court's holdings for at least two reasons. The first is for the fact that Stammel did not preserve the appellate review, for appellate review any arguments concerning alter ego.
But in his affirmation, as your adversary says, didn't he raise alter ego?
In his affirmation, he has one conclusory statement that he is not an alter ego. The words alter ego are not anywhere in his motion to
But
dismiss.
doesn't that put you on notice that that's the claim, that he is not the alter ego?
Well, so he filed the motion to dismiss. He did not file a reply, and the court, I correctly held that that was not sufficient for him to raise that issue.
Denying that he was the alter ego of the company is not enough?
A single conclusory statement in an
What else did he have to say?
set forth the facts that demonstrate that he's not an alter ego.
Well, what facts were set forth that he was? Other than him being the attorney, the treasurer, the secretary, the director.
Sure.
I don't know what other hats he held, but, right? You know, I mean, those were all conclusory allegations as well. And as your adversary pointed out, there was none that I could see, not one factual statement about what he transferred, that he dictated or demanded, directed, importuned anyone to transfer anything. So
we submitted a few things. First, and you can find this in the record at, believe page 372, that we submitted an SEC Form 1, which demonstrates that not only that he held multiple roles, we demonstrated that he was the co-founder, the vice president, the secretary, the general counsel, the board member. He was the one responsible for filing the SEC form that dissolved the original.
But that's all
entity.
part of corporate governance, no? There's no law that prohibits one person to hold multiple roles in a company.
The company was, their principal offices were in his own law firm. He dominated that company. I mean, there's a number of things.
Let's assume he dominated the company. What's the fraud that was committed based on the dominance?
Harm, sure. So I would submit that there are two things. First, before judgment was entered, he was the one responsible for dissolving the original company, making it impossible for us to actually collect from that company. Second, when we served an information subpoena on him, he did not respond, also further making it impossible for us to collect or to have an understanding of where the assets were.
You don't believe that you have to show that there was some sort of fraudulent transfer by
No, I think the law is clear that you have to show that there was he dominated the company, and that, first of all, and second of all, that it caused some sort of injustice. And again, the injustice is the fact that we were not able to collect from the original company, and that he didn't provide us with the information that made it necessary for us to understand where the assets had gone. If I may continue, going back to the waiver issue, I think one of the cases what we cite is Gonzalez versus New York, which holds that in a special proceeding, Supreme Court is limited to considering arguments presented in his opening motion, and that is exactly what it did. Again, there was nothing in the actual motion itself that even mentions alter ego. But if we do reach the substantive issue, I think that for the reasons that I've stated regarding his dominance and also the injustice that was caused to us in our inability to collect is sufficient to show that he was an alter ego.
Thank you.
Thank you.
So I think what I'm hearing is The improper transaction here is that the petitioner here couldn't collect. And so my
Well,
client
no,
should
it's
be
not
deemed
that.
an alter
Well,
ego.
No, the assertion is that your client shut down the company.
That's the first I've
as-
heard of
hold on,
that.
Let me finish. That's the assertion. You can
Right,
respond.
right.
And therefore, the law firm was unable to collect.
Look, there's no question. I wouldn't be too glib, seeing as your client hired them to provide legal services and then didn't pay. Okay, so they're not coming here insane.
So it wasn't
all
my-
right?
right. So just so we know, there are multiple shareholders that were sued here. It's not just my client. He's not the ringleader.
that's
and
all
he did
well
not
and
hire
fine.
Quinn Emanuel. The company hired him, hired Quinn Emanuel
was
to
the
perform
company-
services that were disputed.
Was the
But there was a
company-
judgment because it was on default. The company didn't defend it, got a judgment against it, but that doesn't make someone an alter ego.
Was the company then shut down by your client?
Not that I know of, no. And even if it were, that would be in the normal course of business. And I don't even know when it was shut down because they got a judgment against the company. So what we have here is we have the company was issued an information subpoena. It was sent to the address where that was designated, which was a law firm, which was my client. He was the lawyer, general counsel of the company. And the information subpoena purportedly wasn't answered. So show me one case where an information subpoena is not answered and then the person...
You mean that in the form of an argument, right? Because you're not
there's
asking.
No case. No,
Okay.
there's, I submit
Good.
there is
I'm
no case.
glad.
There are two cases that petitioner cites to, but they don't find alter ego because someone didn't answer a subpoena. They find it because there was control and domination, and then there was an improper transaction. I don't know what the improper transaction is here. It's not alleged. And until we have discovery to find out if, in fact, that even happened, this should not be sustained, so I submit it should be remanded. Thank you.
Thank you. AAG Management versus New York State Urban Development.
May it please the court, Richard Emery for appellant. First of all, I just want to take care of some business because we omitted a case that was cited below but isn't cited in our briefs here, which is, I think, on all threes at least, if not on all fours. It's Develop, Don't Destroy, and it's in this court. Justice Mazzarelli wrote, it's at 94 AD 3rd, 508, and it has substantial similarity to this case because this court did not defer in the way that the ESD is going to argue that you must defer to the issue of a GPP that was outstanding and that was subsequently not followed through on and changed because of economic circumstances in the Brooklyn development of the Barclays Center and that area around it. And very similar to this case, which the genesis of which was in 2018 with the former governor and the legislature saying, we've got to do something about Penn Station. And they allocated $1.3 billion at that time, and they went ahead and said, ESD, let's do something about Penn Station. 4 years later, after a lot of work, the GPP was before ESD, but at that point, COVID was raging for 2 years. It was very clear that the office market was gone, that it was not a cyclical thing. This was an economic disaster that is going to last forever about the need for office space in New York City. Essentially, Roth and Vornado made it very clear that they were not going to build these 6 super talls, which the theory of the entire case was would fund the renovation and the immediate environs of Penn Station. And that was clear at the time. There was no financial analysis whatsoever in the submissions to the ESD board. They simply went ahead and adopted the GPP as if those 6 super talls and the other areas of the development were going to actually occur. There was no possibility that they were going to occur at that point.
But doesn't the GPP provide that prior to construction of each of these projects, that there's going to be, they'll enter contracts, they'll hold hearings, and it'll be done on that basis. What's wrong with that approach?
What's wrong with it is that there was never, the GPP has to, under the statute, has to justify its own purposes. And there's no doubt that under the individual development agreements that might be allowed in the future, there would not be anywhere near the income that was contemplated. In fact, that's why the governor, shortly thereafter, decoupled the entire process. So decoupling means, obviously, that there was a coupling prior to that.
Going back to the statute, doesn't the statute say if there's adequate provision has been made for payment of the cost of acquisition or will be made?
Right.
So that suggests to me that that's something that can occur in the future.
But here, there's no more will because there's no office market. There's none of the planning that was underpinning of the entire concept of rehabilitating
Is there a
Penn
zoning
Station.
problem that would prevent there to be a reimagining of this GPP, and instead of 6 tall office towers, perhaps mixed use with residential, which this city sorely needs?
Absolutely correct. That could very well happen.
Okay.
However, this GP would not cover it. They'd have to go back. They'd have to go through the EIS process because at some point, when you change it dramatically, and the purposes of the GPP, namely to fund Penn Station and the environs of Penn Station, could never be achieved, then you have no purpose for that GPP. You can have another GPP in the future, as Justice Manzanet is positing, but it's a different purpose. And in fact, the governor said when she decoupled, residential, we want to emphasize residential in the future. But that's a completely different GPP, not this one. The problem with this GPP is it hangs out there like a pall of the entire neighborhood, overriding the zoning.
So would you disagree that it's still the case, as it was when this was started, that there is a fairly large consensus that Penn Station needs to be upgraded?
I'm sorry.
That Penn Station needs to be upgraded.
Oh, there's no issue in that.
So in that sense, the GPP doesn't cast a pall, but some hope, right?
The GPP no longer has anything to do with the upgrade of Penn Station. The governor has made it very clear that all the money, the $7 billion of the $22 billion that is going to be required, that is New York State's share, is going to have to come from somewhere else. It's no longer part of the GPP, even though that was the genesis of it in 2018 with the governor and the legislature to fix Penn Station, to create an environment where Penn Station is up to the...
But the other purpose of the GPP was to fix a neighborhood that for decades has been underutilized, has an increase in crime, and is, quite frankly, just not a nice area of the city to walk through at night.
If you go up to 33rd Street tomorrow, you'll see that it is actually thriving. More than that.
Counsel?
More than that. No, wait.
Counsel, please don't tell me.
All right.
Do not believe what my eyes see.
Okay.
Okay? Don't make that argument.
There's a portion of that they focus on what they call blight, and I commend to you the Conservancy brief about blight because it's excellent and explains it very well. The portion is only in sections 1, 2, and 3 of the site. All the Vornado sections, 4, 5, 6, have no, 4, 5, 6, and 8, I think, have no blight even alleged.
Really?
So there's no, in those sections, there's nothing. So I just say to you that there's no current purpose that even reflects in any way the original purposes of this GPP in order to come to fruition. There's no money that can be generated for the purposes that it was originally conceived.
Okay, we got it. Thank you.
May it please the court, Philip Carmel for the New York State Urban Development Corporation, doing business as Empire State Development, or ESD. Let's start with something undisputed. The Urban Development Corporation Act requires ESD to make certain findings when approving a GPP, and it is undisputed that ESD made those findings here. So the only question before the court is whether there was an adequate basis, or a rational basis in the record for the findings that ESD made.
Should we defer to the ESD's findings of Blythe? Because clearly your adversary says we shouldn't.
Absolutely. There's case law that says deference is required from both the Court of Appeals in this case and this court. So deference is absolutely mandatory. This is not a de novo proceeding on Blythe. I want to start with this issue with this project being not economically viable, which is perhaps the main point that was made in argument. There's no legal authority for that being a valid basis to challenge a general project plan. But let's put that aside. What does the record say about the economic viability of this project? The record says that ESD concluded that the market for office space in New York City is stratified with robust demand for office space in new office buildings in transit-accessible locations that are built to a top-tier Class A standard and that have green sustainability features. And that is exactly the kind of office space that would be included in this project. It's in a transit-accessible location. The new office buildings would be new and Class A, and under the design guidelines that are attached to the general project plan, they would have very rigorous green sustainability features. So ESD concluded that there would be demand for this type of office space. Now, what was that conclusion by ESD based on? Is there a basis in the record for that? Yes, there is a basis in the record for that. The Cushman and Wakefield report and the BJH memo.
Well, that was all pre-COVID, correct?
No.
It wasn't.
No, the Cushman and Wakefield report has extensive discussion of COVID and an extensive discussion of why the COVID pandemic would not dampen the market for new office space of the type that I've identified.
But 6 tall buildings worth?
Absolutely.
That's a lot of office space, and we have a lot of buildings throughout this city now that are empty.
As I've said.
And not all of them are old, decrepit buildings, okay? So I admit to you that I'm sure there's a good share of them that are, but not all of them. And you know, we have a phenomenon now of businesses throughout this city and state sharing space because the market has been turned upside down. So why isn't your adversary's arguments about this project not really being viable at this juncture, maybe 10 years from now, right? When the market recovers from the COVID hit. And there was a hit, there's no question.
Yes. This project has a long-term time frame for 20 or 30 years. So there will be a recovery of the office market. And the question is not...
So you're saying the first building probably wouldn't be finished until about 10 years from now?
It may not be finished for several years. That's consistent 100% with the ESD plan. I would ask the court to look at the record at the Cushman and Wakefield report. It contains page after page of analysis and statistics to back up the conclusion. Appellants do not even discuss the Cushman and Wakefield report or the BJH memorandum, much less demonstrate that it was irrational for ESD to rely upon these documents. The fact that people might disagree about the future of the office market is not a basis to annul the general project plan, because ESD did have a rational basis in the record for its analysis of the real estate market. ESD also is the state's preeminent economic development agency.
How does the governor's announcement of decoupling affect the project and your arguments?
It doesn't affect...
Certainly with regard to financing.
It doesn't affect the project at all.
How not?
Well, the principal purpose of the project.
No, I'm talking about the financing, right? So if I understood the papers correctly, it was through the development of these buildings and the revenue that the state would generate from that activity that would help fund the Penn Station. So if it's now been decoupled, where's the funding coming from?
That is
They're not required to be at the table. They can get to the table whenever they want. They own the property. So how do we get there?
Funding Penn Station is not the principal purpose of the project. That's very clear from the general project plan. We've cited in our brief that the principal purpose of the project is to address the substandard and insanitary conditions in the area and to build the civic project improvements that are actually part of the project. The governor's statement only pertained to the Penn Station reconstruction project. It had nothing to do with the Penn Station expansion project, which is still expected to cost something like $13 billion. So if there are excess monies generated by the ESD project, above and beyond what is required to fund the civic project elements that are actually the construction projects that are part of the general project plan, they can go to the Penn Station expansion project. That was not even addressed in the governor's statement. The governor's statement did not change this project in any way.
Okay, thank you. She gets 1 minute and then you go.
Good afternoon. Emily Cooper, Fried Frank, Harris Shriver, and Jacobson on behalf of intervener respondent Vornado Realty. Again, as Mr. Carmel said, the GPP is a long-term plan for urban revitalization through the precise private-public partnership that is encouraged by the UDC Act. To Your Honor's question earlier, it is a long-term plan. The ESD project, which does include residential as well, is estimated to take 22 years to complete. That is by the end of 2044. The first buildings anticipated to be built are assumed to be completed over 11 years. So the purpose of this project is a long-term plan for the Penn Station area that is not dictated by short-term economic headwinds or cycles of the economy. So again, we join Mr. Carmel's arguments with respect to that ESD made both in their briefing today, and if Your Honors don't have any questions, I will take my seat.
Thank you.
To address the Vornado position, the Vornado's deafening in its silence in its brief say that they're going to build. They're not going to build. They've said it over and over again publicly. They're not going to build, and that is the genesis of this entire project. Was the governor and Stephen Roth coming up with a way to fix Penn Station and fix the expansion as well as the reconstruction. Page 1 of the GPP talks about funding these things. Yes, there's of course funding, but the funding for the other civic purposes is maybe $2 billion, and 1.3 of which has already been allocated. So that you have $700 million, which in these terms is a drop in the bucket. You're talking about $7 billion at least that they intended to raise by these super talls. So the whole purpose, the original purpose of the GPP was destroyed by COVID. And they can't run away from that. In fact, the governor has dealt with it by decoupling it and saying the money's got to come from somewhere else.
Is this something that we can really even consider as to the purpose now is finished and there has to be a new plan?
Yes, absolutely. Look, that's why I cited to you, and I'm sorry it's not in the briefs, the Develop, Don't Destroy opinion by Justice Mazzarilli in this court, which did very much the same thing. It vacated a GPP because the timing was not, there was an economic downturn. That was a cyclical downturn. This is not a cyclical downturn. This is the end of office space in the way that we knew it in the past. And it just because of a cyclical downturn and the extension of time and the environmental consequences of that, she vacated the GPP, affirmed the lower court.
Thank you. We'll take a look. Batage versus Dahl.
Can I just correct something that was
No, I
misstated to the court?
Nope, not permitted, but thank you. Batage versus Dahl. You may proceed.
Good afternoon, Your Honors. May it please the court. Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in awarding summary judgment to the defendants in light of conflicting medical opinions on departure and causation questions. It's uncontroverted that the plaintiff went into a nasal surgery with minor complaints of muscle weakness and tenderness in her shoulder and came out of the surgery with throbbing shoulder pain and a full-thickness rotator cuff tear. Plaintiff's expert, a board-certified anesthesiologist, opined that this resulted from defendant's failure to properly position her with padding and contoured arm boards.
Was that raised in your bill of particulars?
Yes, Your Honor. I would submit that that argument, that theory of liability, is included within the BP allegation at page 95 that there had been improper positioning of
But how would that
plaintiff.
put the defendant on notice that you're not talking about really the improper positioning, but what you're talking about is lack of padding?
Well, but the padding and the arm boards are part of the positioning, right? So not only is it supine, but in addition to being supine, it should have been padded and contoured arm boards. So we submit respectfully.
So that's extra than just position, right?
Pardon me? I'm sorry.
It's more than just how she was laid or positioned.
Well, it's part.
It dealt with the apparatuses used for it, and that wasn't included.
I would respectfully, first of all, I think that this is the dispositive issue on the appeal. I think that if we overcome this issue, that a reversal is clearly mandated.
Well, there's a
because of
second
the
issue
tribal
too,
issues
but
of
there's a
fact.
second issue too, but go ahead.
So, but on this issue, I would submit that when we talk about positioning, it's not just whether someone is supine or situated some other kind, but some other way, but also what devices are used in that positioning. And I would respectfully refer the court to the Cassiano decision, which was recently decided by this court, September 26, 2024, in which this court, Justice Manzanet was on the panel, this court came to the conclusion that reference, and this is in a different context, it's analogous in the sense that it was a theory of liability that insufficient fall prevention was in place. And in that case, the argument was made by the respondent that when the plaintiff expert started making reference to things like padding, for example, and other measures that could have been utilized to effectuate that was a new theory of liability. And this court rejected that and said no.
That was counsel, that case involved a patient, if I am correct, who was allowed to fall like 14 times. That is not this case.
No, it's not factually on floor, but analogous in the
There's
sense that
there's
there
no
was...
evidence that anything even happened during the surgery that would have caused a full rotator cuff tear, okay?
On the
nothing, there's nothing.
So that's the second issue, right? So even assuming that you're right on liability, the defendants say that force is necessary to cause the tendon to tear away from the humerus. So how has your expert addressed that issue in terms of how the rotator cuff injury could have occurred?
So the way that the expert addresses that is by making reference to the fact that when one has this type of injury, there is, and as we see here coming out of the surgery, a significant amount of pain. And coming into the surgery, there was no reference to any significant pain, contrary to the motion court's determination at page 8 in the record, and I see that my light is on, if I may just finish this point. There was no reference in the MRI report to any degenerative changes or any degenerative condition at all. So what we have is we have a situation where there's no evidence in the lead up of any degenerative condition whatsoever. And coming out, we have a person that's in throbbing pain that has a full thickness rotator cuff tear.
Thank you. Thank you.
Thank you, Your Honors.
Rosenthal versus Sperling. You may proceed.
Thank you. Good afternoon, Your Honors. Eric Leiter of Morrow Lilling Party for the defendant's appellants, Dr. Danny Sperling and Sperling Radiology PC. In this case, there are many errors that were committed at the trial, but I'd like to begin by noting what the plaintiff's biggest problem was at the trial, which he never overcame, and makes the resolution of this matter simple because it warrants the dismissal of the claim in the entirety, which is that the plaintiff never genuinely established a prima facie case on causation. His own expert admitted that the biopsy was the proximate cause of the injuries, and then we know that there was no allegation of liability premised upon the biopsy. The liability allegations were premised upon the ablation. And once his own expert conceded that the proximate cause was the biopsy, not the ablation, and no questions went to the jury about the biopsy, the case was dismissible and never should have reached the jury. And so, although the court seemed to believe that the presentation of hypotheticals to those expert witnesses could save the plaintiff's case, it clearly could not under controlling case law, because the plaintiff...
I'm sorry, didn't the expert testify that this is Dr. Blassel, that the procedure was experimental, contraindicated, and which caused injury to plaintiff? Isn't that sufficient to go to the jury on that?
His only response to any question like that was in response to the hypothetical. And in that hypothetical, he was told to assume that the ablation resulted in the injuries. He did not independently determine that the ablation resulted in the injuries. And you can't, it's circular, and you can't have a hypothetical in which what you ask the witness to respond to is the very same thing you've asked them to assume. You can't ask them to assume the Statue of Liberty is 500 feet and then ask them, based on that hypothetical, how tall is the Statue of Liberty? That's not of any probative value. And that's the problem that they had here. Next, even if the plaintiff had in any way established a tribal issue of fact on that point, the defendants are still entitled to a new trial of all issues we submit because the verdict that the jury returned was both confused and inconsistent.
What was confused, and did you make an argument that it was inconsistent before the jury was discharged?
Yes, Your Honor, we did. On November 20th of 2019, the defendant specifically noted that they found the verdict to be inconsistent. They also noted that they wanted polling of the jury. The jury was not discharged on November 19th, as has been wrongly suggested in the plaintiff's papers. The jury was not discharged until, as this order that we're taking the appeal from notes, the trial court dismissed the jury on October 18th of 2022. Going back to the prior order of the same court, which we had an appeal from, which was the August 18th, 2021 decision, the court specifically noted in that order that the jury is still impaneled, that they had not been discharged. What happened on the 19th was that they were...
But that was for a separate issue, right?
Yeah.
The damages issue, correct?
You were coming back for punitive damages. Under the case law, if you find that a verdict is inconsistent, you have to make that argument then in order to give the court an opportunity to send it back to the jury for them to fix it. Was that done here?
That was done here because...
At the time of the trial?
Yes, at the time of the trial, because the trial was not...
No. Counsel, don't talk to me about 2-3 months later. That is not enough, and that is not the right time. It is when the jury comes back with your claimed inconsistent verdict. Was it done then?
Your Honor, I repeat...
Was it done then?
Yes, because the jury was back on December 10th. So to say that this was not done when it was done on November 20th, and the jury was back on December 10th of the same year, and the judge made a point...
That's not what our case law says. But go ahead.
The case law, as we address it in the papers, is that the final time is when the jury has been discharged from all further service, and that in a bifurcated case, and the Pickering case is the one in particular we noted, because in that case the court specifically noted that if the defendant had any lingering issues, any questions about an inconsistency or problem with the verdict, they could have raised it several days later. It noted that they could have done that a few days after it had already received the verdict on the first portion of the bifurcated trial, but it couldn't do it after the jury was discharged following the completion of the second portion of the trial. And relatedly, cases have held that the parties don't even have an actual right to demand polling prior to the completion of both parts of a bifurcated trial.
But here the judge asked both parties whether they wanted the jury polled, and both of you said no.
She did, that's correct.
Okay,
But as the
so there
case,
can be no error on that.
we submit that under the,
You said no. She asked the question and you said no.
yes, if it could be an irrevocable waiver, that would be true, but the case law holds that it's not. And I also want to address, because we have many issues and they're a limited time, on the issue of punitives. There's the inconsistency of this jury found that a reasonable person would have consented to the ablation of the tumors. At the same time, this jury, which, as this court noted in one of the two cases that I submitted as a recent decision less than 30 days ago, that if that element is missing from an informed consent claim, that is the end of the claim. Yet this jury found that a reasonable person would have consented, and at the same time, in its responses to questions 13, 1A, and 1C, said that punitive damages were warranted based on the performance of the procedure, that that Dr. Sperling was wrong to perform any ablation of any portion of the tumors, and simultaneously depart from the standard of care by not ablating more of the tumors. And those four things cannot be reconciled with each other. That makes an inconsistent verdict. Defendants were also prejudiced.
The punitive damages that portion was vacated, correct, for a new trial?
The judge has ordered a new trial on punitives.
So why should we even address that issue at this point? If there's going to be a new trial on that, and presumably at that point, you can raise your issues then about inconsistency if you haven't waived them already.
Because the issue before this court now is whether the court properly allowed the plaintiff to amend his pleadings to add those claims. And the answer to that is the court did not. As Judge Capella's prior ruling.
Was Judge Capella's ruling on the merits?
Yes, it was, as to whether or not there were two issues. So on one it was, and the other it was not addressed. On the issue of whether he should have been allowed, the plaintiff should have been allowed to amend their pleadings to add a punitive damages claim about experimental and investigatory, that was on the merits. On the other issue of spoliation, the most important thing is to note that in the other case that I cited to this court, what the plaintiffs urged the trial court to read Gomez as, and is the only case either plaintiff or the trial court ever accepted as being the basis for the spoliation-based punitive damages, has been rejected by the Second Department in a case where the plaintiff's brief explains that they alleged that in a medical malpractice action, that the defendant added over 350 words to the record after he had stopped being a patient of that doctor and had requested the records, and argued that he was entitled to add a claim of punitive damages. The Second Department has now affirmed that it was proper for the trial court to deny that motion, that they are not warranted, and it cited Gomez.
Clearly, we're not bound by that decision, but I'll hear you on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors. Excuse me, Jonathan Dax for the plaintiff's respondents. There's a lot I want to say and not a lot of time to do it, but I'm going to first.
So can we just work backwards regarding
Sure.
the addition of the punitive damages? The court is permitted to allow the plaintiff to amend pleadings to conform with what is adduced at trial, correct?
100%.
And is that not what the court did here?
That is exactly what the court
And
did.
the punitive damages was added based upon Dr. Sperling falsifying his medical records. That was a
It's
basis, right?
That was one of the two bases. The other basis was the fact of, with knowledge that this procedure was experimental or investigative, and under the obligation to therefore notify the client with full consent, so there could be full consent, he did not even put that in his consent form. So it was the two. But certainly that's the way it played out. And the cases that I've cited in my brief.
Judge Capella's decision to deny punitive damages before trial, was that on the merits?
Is clearly not on the merits. He said it's based on the fact that there was no expert testimony yet, kind of alluding to the fact that if I was trying this case, I being Dr. Justice Capella, I might have a different response to it if the evidence came out of trial. Well, when the evidence came out of trial, there was a different trial judge, and she certainly had the right and ability to supersede Justice Capella's order, and that's exactly what happened. There's hundreds of allegations, there's insulting language, there's all this stuff in this case. It's not a clean case.
Can we address the issue of waiver?
Waiver
Was there, in terms of polling the jury, and your adversary says there are inconsistencies in the verdict.
Well, they did not raise the inconsistencies. As part of what I was about to say, this is a kind of a strange case in certain ways because there's a lot going on in terms of he doesn't mention, you never heard mention of the fact that there was a bankruptcy stay that followed. I mean, it's a big deal. You can't ignore it. They filed for bankruptcy, and there was an automatic stay. Justice Singh, you were on this case when it was argued on the first appeal about a year ago, November 21st of 2023. So the arguments that we didn't, or the judge didn't wow, I'm sorry. They couldn't poll the jury. The argument that the judge didn't poll the jury, she couldn't poll the jury because the next time the jury was seen or heard from, there was a stay in effect. And at the argument that you were part of.
But immediately after the trial, she offered to poll the jury, and both of you declined.
Absolutely, both sides said no. They claim in their papers that some memo on another topic that was written the next day asked for it again, but at that point.
And wasn't there some discussion that threw into question whether you would end up with the same jury?
Well, that went on for quite a while.
Yeah.
And in fact, defense counsel didn't want the same jury to come back, and we were trying to get the jury to come back and hear the new charge on punitive damages. So they did a lot of things that weren't kosher. I'll leave it at that. And you know, just the way they go about these arguments, there's been some lack of candidness and impropriety throughout, and they're still doing it now in the appeal, which boggles my mind, because you don't do that in this court. You don't do it in any court, but they're still doing it. With regard to causation, which was the first issue counsel raised, this is another example of how they twist the record. The testimony by Dr. Bagla, if that's the way you pronounce it, about the biopsy, began a series of questions about deviations from the proper medical certainty, conduct, and all of that. And there's one set of questions that on pages 1228 to 1231, where Dr. Bagla first is asked about whether he would have performed a biopsy under the circumstances of the x-rays and MRIs and all that. And he opined that he would not have done a biopsy because it wasn't necessary.
Based on the scores.
Based on the scores.
Right.
And certainly it wasn't necessary until maybe later it would be necessary, but he was saying at this point in his life and his medical condition, there didn't need to be a biopsy. So he found a deviation in performing the biopsy. There was then a question, did the biopsy cause injuries to my client? And he answered that yes. And then there was some colloquy, there was objection. And then the next question that was asked at the end of the colloquy is counsel, who I believe realized that is not the way to go to talk about the biopsy. It's the way to go to talk about everything else that happened. Asked questions about, was it a deviation to perform this FLA procedure without proof of cancer? Because we know that's what happened here. He told the patient he had an 80% or more chance that it was cancerous.
On the basis of an MRI.
On the basis of an MRI, on the basis of that he wanted to scare the hell out of his patient and get paid and take off to Florida. But that's what happened. And then all the questions that followed on pages 1252 to 1258 are all about the procedure and not the biopsy. And it's very misleading to say that he testified that biopsy was a departure and no other questions were asked. I mean, it's obvious what happened here. So you can't pull the wool over your eyes. I know that's something you're not supposed to say to a jury, but I could say it to you.
And the hypotheticals that he referenced, those were hypotheticals as it related to your client and the biopsy, right?
My client and
the biopsy, in terms of the numbers being what they were and whether in fact he would have performed a biopsy with those numbers being what they were.
That was part of it, but so was the procedure itself, the FLA procedure itself. And let's not forget that we have testimony by Dr. Vapnek also giving causation in very clear terms. There was testimony before and after the hypotheticals. The hypotheticals were long, yes, but they were thorough and they were well prepared. and there's no reason why they shouldn't be given full credence.
Thank you.
I'm going to leave it at that. The briefs are very straightforward. It's allegation and destruction of allegation, and it goes one by one by one. It's very organized. If you line them up, you'll see there's a response to every one of his false allegations, and for that reason, and the procedural reasons, which I didn't get a chance to talk about, which were that this is a repeat of many issues that were already determined.
Got it.
Thank you.
Thank you.
Thank you, Your Honors. I'd like to note that even if this court weren't to find that there was an inconsistency or that the argument was not preserved, there would still be a new trial warranted given the errors in the evidentiary rulings by the trial court, including allowing the plaintiff's attorney to tell the jury that he had a decision from the United States District Court for the District of Maine that came down in 2019 in January and declared as federal law governing over the whole nation what the law is, that laser ablation procedures are experimental, investigatory, and not for human use. It's now undisputed that that is untrue, but that the court permitted the jury.
The lawyer said that. That's not evidence.
The lawyer introduced that through the witnesses. He said, "Are you aware of this?" And the lawyer asked the judge to take judicial notice of the document, even though it wasn't actually a decision from a federal district court judge, and the court took judicial notice of it. So the court made that the law of that trial, that this was not for human use, that it was experimental, that it was investigatory.
Wasn't there other evidence to do that it was experimental?
No, not in the terms of.
Both doctors testified that this was an experimental treatment, that only the device had been approved and not the treatment itself, that the device was approved, but not the treatment. And there was nothing in the record that disputed that.
That was the error of the court permitting the plaintiff to discuss FDA determinations, when every case in every state, as we cite in our papers, holds that they're irrelevant. And that's not a determination from a medical determination, from a medical standpoint, because the FDA.
Performing a procedure that is not FDA approved, you say is of no import in a medical malpractice case, where the doctor does not advise the patient that I am suggesting that you have me perform a procedure that has not been approved?
I have to explain why the answer is no. The reason the answer is no is because the FDA never approves procedures. The FDA doesn't govern the practice of medicine.
All right, thank you. Thank you. People versus Pari.
May it please the court, Abigail Everett, Center for Appellate Litigation for Mr. Perrier. Turning to the condition of probation issue, and specifically the consent to search provision in the conditions for sex offenders. This case, you have to keep in mind, there's one set of conditions of probation for sex offenders. There's a separate one done at sentencing, not related to sex offenders. And in fact, if you look through the file papers, there's a third order of conditions of probation done at sentencing for sex offenders. So there are two sex offender, one non-sex offender, all signed by the judge, all signed by the defendant. So I'd like to turn to some of the arguments that the DA makes here. First, they say, on the question of whether this condition is reasonably related to rehabilitation, they argue, well, this is a well-established condition for sex offenders to have to give consent to searching. Well, I would like to point out a few things on that proposition. First, the legislature did not mandate this for sex offenders. It is something that if the record supports it and it's related to rehabilitation, the judge has the power to impose, but it's not for all sex offenses. Also, I would submit, getting back to that question I just raised about the two different conditions of probation for sex offenders, the one at the plea, which is what I'm talking about, has this condition. The one at the sentencing, which is also a form for conditions of sex offenders, the judge did not check that. So again, it's not that this is a routine condition that is always imposed for sex offenders. Another factor I'd like the court to consider on this is this case People v. Saraceni that's cited in both my brief and the DA's brief. That's a Fourth Department case involving sex abuse in the first degree, where the Fourth Department held in that case that the condition of consent to search was not reasonably related to the defendant's rehabilitation. So it's far from clear as a general proposition that this is something that needs to be imposed. Jumping over for a minute, because my time is limited, whether or not this record is ample to show this is unnecessary. The DA also asked this court to consider that the defendant, in their view, consented to this because it was discussed in the DA's brief, they say, at the plea. But if you look at the transcript of the guilty plea, you'll see the judge says, and as a condition of this plea bargain, you're going to have conditions of probation, including sex offender registration, and you're going to have to do sex offender treatment at this new Paradigm program up in Albany. Just to clarify, Mr. Perrig lives in Schenectady. He's up in
What's your position? Is your position that there should have been, that the judge needed to make a specific determination, consulting or hearing argument from defense counsel with respect to, put aside the issue with the drug stuff, but the sex offender special conditions? Was that not required here?
Much as I wish the court would say it should all be done on the record, there is a case from this court that says that as long as the defendant is given the conditions and signs it, that's enough. The court's current case law doesn't seem to require an actual colloquy on the record. I think that's unfortunate because what happens is, and I'm semi-retired, I'm doing a lot of plea cases now, I'm seeing a lot of conditions of probation. There's a lot of sloppiness that goes on here. And if the court asks the judges to do this on the record and to discuss why they're imposing certain conditions, it would make your job a lot easier to know whether or not the record supports. And in fact, if you look,
so is that the request, that we send it back to the trial court for them to have that colloquy on the record?
I would actually ask in this specific case, because he lives in Schenectady, he's a 70-year-old man, he's in sex offender treatment up in Albany, and I believe that the record amply shows lack of support for this condition. He's the first offender at 66. There was no weapon used in here. There were no drugs alleged, which was why Sarah Seedy, the Fourth Department, set aside this condition.
The issue is not so much the drugs, it's really the sex, the special sex.
There was no internet used in here, so that this record, I think, enables this court to set this condition aside on the record without remanding, and it would be a burden on Mr. Perrig at his age to come down from Schenectady to have a resentencing procedure. So I think that's what I'm asking for the court to just strike the condition of probation. Thank you very much.
Good, I guess, evening now, Your Honors. Noah J. Sexton for the people. I just want to begin by clarifying that we're not saying that as a general rule, sex offenders should be subjected to warrantless searches for things like drugs, weapons. That's actually why we partially conceded that particular search
But why
provision.
should there be a warrantless search ability on his computer, for instance, when the underlying crime had nothing to do with that?
I mean, there are a few reasons why I believe that it's related enough to his rehabilitation to justify it. I think first off, when he was, apprehended by police and initially questioned, one of his first statements was, "It's not a big deal. I see nudity on the media all the time. It's not that big of a deal." Now, he said TV to clarify, but I think that logically that can be extended to, things like streaming services in this increasingly
But doesn't that
post-IPV
suggest that
world.
there could be colloquy that the court should inquire or make an inquiry, and then defense counsel can respond, the prosecution can respond, and the court can come to a reasoned decision as to whether or not a condition is appropriate?
I mean, that can already be done when they're, given this, at sentencing, this list of conditions. It actually does happen, not typically in sex offender situations, but for the drugs and weapons. They can move to strike that condition.
But why shouldn't that happen as a matter of course each time there's a sentencing and there's being additional conditions added?
Because I believe that while it's good to have the option there when they feel that there is, something that they want to controvert, it's not something that it's not a burden that should be placed on the court every single time, because oftentimes these people are fully apprised of what the special conditions are going to be at
Which
sentencing.
these people are you referring to?
Just defendants generally. And they're appraised in writing of what is going to be required of them. They're given the opportunity to speak, but in a lot of
They're
cases...
not apprised of that
No, they're
until
not.
after they receive the paperwork. They're usually sentenced, told to have a seat, and then thereafter receive the paperwork. So it's not as though at sentencing that probation paperwork is right in front of the defendant and his attorney or her attorney, and they're able to look back and say, yes, we'll take this one, we won't take that one. Do you understand what I mean?
I understand, Your Honor. And I guess I would also point out, just as something that they can do in the court below, obviously not contemporaneous with the condition being set, is that they can move to modify the conditions of probation under the correction law. That's 6001(2)(b), that they can do
But
that.
why should we burden the court with additional appearances, et cetera, when in the first instance, when you are sentencing someone, there should be a thoughtful review of what's on these conditions. The defendant should know exactly what they are prohibited from doing, not after the fact, but before they're sentenced.
I understand. If I could just
Yes,
respond.
I asked it, I want you to answer.
I do believe that ultimately, at the exact time of sentencing, the court may not even be apprised of what the special conditions are going to be at that exact moment. I just think that by having it be a separate proceeding, it allows them to build up an argument. It allows the court to understand what's being required of them at this special condition.
Yes.
So, are any of these special conditions here that were imposed on the defendant, are any of them required by law?
They're not required by law. The sex offender conditions, just standard application, typically require an offender to stay away from, pornographic material, things like that. But you don't, other than, standard having to check in with a probation officer, things like that, there's no requirement that you have warrantless searches and seizures. It completely depends on the case. If there are no further questions.
Thank you.
Just like to address briefly the idea that Mr. Perieg's statement that you could see worse on TV somehow suggests that he's perusing the internet for child pornography. I think that's a bit of a stretch, and I would ask the court not to find a basis in this record.
And while I am empathetic to your client's difficulties in traveling into the city, but it seems to me that if an inquiry really is what is required, then I don't want to foreclose that out of inconvenience to your client.
I understand that, but I would ask the court to consider looking at some of the cases where the court has previously set aside conditions of probation that are cited in our brief, that is not the routine practice of the appellate divisions to remand. There are plenty of cases cited where conditions of promotion have been set aside at the appellate level because of a finding that the current record does not support the condition of probation. And here, for the reasons I've stated earlier, this record does not support a need for to do a warrantless search of his computer at his home, at his person, at his vehicle. And for that reason, the court should strike the condition rather than remand. Thank you.
Thank you. And last but not least, Chan versus Havermeyer. You may proceed.
Good afternoon, or evening, or late afternoon, Your Honors. Ethan Brescher on behalf of Yucca. The overarching issue on this appeal is whether there was a fiduciary duty running to Yucca, an entity managed by one of the individual plaintiffs from defendants, i.e., did Yucca have a relationship of trust and reliance on the defendants, which they knew and took advantage of for what they were solicited for, which was a already done refinancing, but what was in fact a amendment of a loan that was about to go into a default that was, and the amendment was guaranteed by the manager of the project and his mother, which was never disclosed. The other plaintiffs have been...
So in other words, it's sort of an intent argument that they intended to use these monies for other purposes, therefore there's a fiduciary relationship?
Well,
Is that your argument?
Well,
'Cause what's the difference between what we said before and now? It's just that, right? You know the motivation, correct?
it was a bait and switch. They were what was concealed, what they were solicited for was a beneficial refinancing at an advantageous interest rate, and what in fact they were being solicited for was money to fund an interest reserve top up of.
But why should that be the basis to say now there is a fiduciary relationship between the parties as opposed to what we said earlier that there wasn't?
Well, the court never reached the issue of whether there was a fiduciary duty, but it said it was never pleaded before. If you read the court's decision in Havemeyer 1, it said the UCA had never pleaded a breach of fiduciary duty. So therefore, it wasn't before the court. Even the defendants themselves said it wasn't pleaded. And therefore, the doctrine of judicial estoppel, which was accepted by the court, meaning that it wasn't pleaded, applies. So this court never got to the issue of fiduciary duty.
But we say in the order, by contrast, Havemeyer did not owe a fiduciary duty to plaintiff UCA, which, unlike the individual plaintiffs, was not a pre-existing investor.
Right, but
So
the sentence before.
I'm not sure I agree with your reading of the case.
But it also said it wasn't pleaded. So there's certainly a lack of clarity in Havemeyer 1.
Oh, is there?
With all due respect.
Is there now?
And even if
So your argument is Ronnie, right? The Court of Appeals case. That's what you're saying that you don't have. There are circumstances which there can be a fiduciary relationship here.
under the Ronnie decision from the Court of Appeals, even where it said where they're not a pre-existing investor, the court says it's a fact-based decision as to whether there's a fiduciary duty.
So let's talk about that. Right. So how are the allegations of your complaint the same than what was said in Ronnie? In Ronnie, the promoter, the folks were foreign investors. You are a U.S.-based investment company, right? So,
Well, the court in
concerns
Ronnie
are different.
The court in Ronnie didn't limit it to just foreign investors. What it said.
Well, with limited knowledge in New York real estate.
My clients also had limited knowledge in real.
But you're an investor. Your clients are U.S.-based.
Investors in other types of securities, but not in real estate investments, and they also the promoters here knew that they were being solicited. They were given a solicitation, a tear sheet, saying we're soliciting you for a refinancing, when they knew at the very same time that they were being solicited for a loan amendment that was guaranteed by the defendant and his mother. And that was not disclosed. There was a massive disparity of information that the defendants possessed over the plaintiff here, which is one of the bases that Ronnie says you look at there's a disparity of knowledge. Here it was massive, and it was never disclosed. They were sold something. They were sold A when they were really being solicited for B, or they were being solicited for A when they were being solicited for something completely different. And so, based on that disparity of information, the promoters here had much more knowledge than my clients did. Ronnie wasn't limited to simply foreign investors. It's not cabined as such. It's broader. It's an issue of fact. Mr. Silvers also admitted at his deposition that Yucca was owed a fiduciary duty. He made an informal judicial admission.
Is he a lawyer? I mean, is
he managed
capable
the
of making that
project.
determination?
But the issue is on the pleadings of whether it's an issue of fact. That is something for a jury to decide. Mr. Silvers managed the project. He was in charge of the project. He solicited money for the project. He knew everything about the project, and he acknowledged that he owed a fiduciary duty to the plaintiffs here. This is an informal judicial admission, and he was the core. He was the center of the entire project, and he admitted at his deposition that a fiduciary duty was owed, which only is consistent with what Ronnie said. The promoter here has a massive disparity of knowledge. And in fact, they were being solicited for something completely different at the time. So we believe that the Ronnie decision controls, and that it's at least an issue of fact that there was a fiduciary duty, and this case cannot be resolved on the pleading by itself. Thank you.
We'll have time on rebuttal.
May it please the court, your honors, good evening. Zaid Shukri, Moses Singer for defendants, respondents, cross appellants. Central issue on these appeals is whether Yucca has sufficiently pleaded a fiduciary relationship. As Justice Singh has noted, this court previously decided, quote, T.C. Havmeyer did not owe a fiduciary duty to Yucca, which, unlike the individual plaintiffs, was not a pre-existing investor. Accordingly, the motion court correctly held that the proposed third...
How about Ronnie? It's not a blanket rule. Why shouldn't we follow Ronnie and say, well, that it's an issue of fact, that they should be able to plead it, and then whether it survives summary judgment is
First, Yucca made the exact same argument on the previous appeal, arguing that it was owed a fiduciary duty under Ronnie. This court rejected that argument by holding that Yucca was owed no duty. Even if this court had not already decided that issue, Ronnie is inapplicable. As Your Honor noted, the Ronnie court found that the defendants assumed a position of trust by, quote, playing upon the cultural identities of overseas investors who spoke limited English and, quote, had limited knowledge with respect to real estate or investments. There are no such allegations here. Unlike the plaintiffs in Ronnie, Yucca is a US-based accredited investment firm. Its manager, Plaintiff Dai Yu, is admittedly a, quote, professional investor, and that's in the proposed third amended complaint at paragraphs 4 and 13, record 175. As to counsel's statement that Yucca has no prior experience in real estate, Mr. Yu, its manager, had already been investing in other real estate development projects with these same defendants since 2016, which is also pleaded in their proposed complaint. Further, Yucca expressly acknowledged in its subscription agreement, which is in the record on the 2024 appeal number at 894 to 896, that it, quote, has not relied on the manager or any of its affiliates for investment advice. And Yucca further said, quote, that it has such knowledge and experience in financial and business matters that it is capable of evaluating the merits and risks of an investment in the company. None of these facts are present in the Ronnie case. Yucca further argues that under Ronnie, an automatic fiduciary relationship arises anytime a company is seeking to raise funds from new investors, but this argument ignores the case law cited in our briefing, including MP Cool and the Copel cases out of this department, holding that there is no fiduciary relationship between a sophisticated, accredited investor such as Yucca and a company soliciting such investors. Yucca further asserts in regards to Mr. Silver's deposition testimony that alone establishes a fiduciary relationship. It is for the court to decide the legal issues in this case. Mr. Silver's testimony does not create a fiduciary duty where none exists. And in fact, Mr. Silver's clearly testified that Yucca was, quote, coming in as a new investor. And that's at page 400 of the record. As this court has already held, Yucca was owed no duty because it was not a pre-existing investor. Turning to the cross appeal in case number 2023-8312, the proposed second amended complaint fails to plead specific facts to support an aiding and abetting fiduciary breach claim against Mr. Rankowitz. I would remind the court first that on the previous appeal, this court sustained the individual plaintiff's fraud claims in the first amended complaint against Mr. Rankowitz.
Did Rankowitz participate in that March 2nd call?
He participated in the call, but there's no allegation.
Did he respond to investor inquiries?
There's no allegation that Mr. Rankowitz said anything on that call.
No, but did he afterwards respond to inquiries?
There are allegations that Mr. Rankowitz responded to emails regarding projected returns and provided his opinions on projections. And there's also allegations that he was a member of Tavros.
Would
which
it be
was
fair to
raising-
say that he has constructive knowledge of what his partners were doing?
We actually cited a case, Kaufman versus Cohn, 30780 second at 126, that states that a status as a beneficial holder or a member is insufficient to establish knowing
But it's
participation.
more than that, right? That he was on the call, he responded to questions. So isn't that a little more than what you're saying?
Well, the main thrust of our argument is that they need to be more specific about what exactly Mr. Rankowitz did that was actionable, that creates knowing participation to hold him liable for aiding and abetting breach of fiduciary duty. And CPLR 3016B requires particularized allegations to support claims for breach of fiduciary duty. On the cross appeal relating to the 2024 case number concerning Yuka's proposed claim for fraud, this court held in the prior appeal that the plain language of the subscription agreement bars Yuka's claim of reliance on statements that the refinancing was completed. Accordingly, the motion court should not have permitted Yuka to reassert its fraud claim because the reasserted fraud claim is essentially based on those same allegations.
It's based on fraud in the inducement for essentially, you say you're going to do something with the investment, but in fact, the plan was to take the monies and then do something different with it. Isn't that a fraud in the inducement?
That's part of their claim, Your Honor, but in fact, the crux of their claim remains that they relied on a statement that there was a refinancing that was completed. They allege that certain obligations that were coming due on this loan that was being refinanced were not disclosed. But this was a $230 million development project. The company has architecture bills, interest payments coming due on certain loans. And what actually happened here was that those funds that were being raised were put into interest reserves on the existing loan. And the idea was that upon the refinancing of that loan, those interest reserves would be transferred to the new loan. And furthermore, there's no allegation that they requested any representations or obtained representations that the funds would be used for any specific purpose. The funds were invested pursuant to an operating agreement that gave the manager discretion to use the funds in the best interests of the companies, which includes paying ongoing obligations and expenses. Finally, I see I'm out of time, but I just note that there's no allegation that Yuka conducted any diligence to verify the alleged misrepresentations, and that alone is fatal to its proposed fraud claim. Thank you, Your Honors.
You have 2 minutes.
Your Honors, first of all, there's no dispute that Yuka was owed a fiduciary duty on March 10th, the day before the email that was sent by Mr. Fu to Mr. Silver saying, glad you already refinanced this loan. Mr. Rankowitz was on that email, Mr. Silvers was on that email, and they didn't correct that misstatement on that email. And at that point, that was a breach of fiduciary duty.
You want to address the fraud in the inducement?
The fraud in the inducement is that the special fact doctrine applies in this case, Your Honors, under the basis case, because what happened was that they were told, they were given a solicitation saying we're asking for money for a refinancing, when in fact they were asking for money for a loan amendment to avoid a default on the loan that was going to happen on March 17th. They were asked to put in money to help prevent the loan from defaulting. Otherwise, Mr. Silvers and his mother, who had personally guaranteed the loan, would be on the hook for it. And so under those circumstances, that information, which was never disclosed, which was solely within the possession of those individuals, under that...
Isn't the theory the same, that it's based on false representations?
Sorry?
Isn't it based on the same theory that we dismissed earlier on? I mean, isn't it the same theory? Now you say that the motivation is different, but it's the same general theory, right?
Well, it's a little bit different, I think, Your Honor, because they were told one thing. They were told there's a beneficial refinancing at at an advantageous interest rate. And what really was going on was that it was to secure money for a completely different purpose, which was the loan amendment. So this was they were told, as the lower court said, this was a classic bait and switch, and that's exactly what happened here.
Thank you.
Thank you.
Your Honors, if I may just briefly respond. We have a rebuttal time on our cross appeal.
Sorry?
There's a cross appeal. I will be very brief. I just wanted to briefly pick up on Justice Singh's point about isn't this, aren't they alleging something new here? And this is exactly very similar to what they alleged the first time, which is that the company was desperate to raise cash, and instead of using the money for the refinancing, it was put towards the existing loan. Now they've just augmented that theory by saying, oh, they were desperate to avoid, because they had to pay these expenses on the existing loan to avoid guarantees. It's very similar. It's almost the same claim. Thank you, Your Honors.
Thank you.